For the respondent, I was humbly praying if I may be
No, it is fixed today.
file my
It was
written notes
kept
on
to
Monday.
be mentioned for filing of written notes on 29.
हाँ हाँ फिर कहाँ है वो? तो वो they are telling इसलिए वो list नहीं हुआ ना. हाँ, so it is not yet listed. It was 29. That's why I'm telling you. You're telling that it's CV.
Lordship, 29.
My
lord may list the matter.
I apologize. Lordship, my humble submission is, Lordship, may I file my written notes?
No,
It's ready.
let the matter is non-commercial.
My lord, it's an originating summon suit. My lord may list the matter at any time, my lord. And we will also file our notes.
कल तो छुट्टी है. Monday list कर दो. Mondays will has to be mentioned.
Very well.
You file, then I will take
Very
on
well.
record.
We'll also file our notes on Monday. Grateful.
Being led by Mr. Mook.
Okay.
Grateful.
Non-commercial.
May I have your lordship's leave to mention item 79 of today's list, my lord? It's an execution application.
79.
79, my lord.
Yes.
Yes, your lordship, the decree, there's a satisfaction of the decree. It might be taken up any day. We have complied with.
If time permit, it will taken today itself. It is in the list.
May I have my lords kindly to mention an application. We filed short application for correction of my typographical errors which have cropped up in my lord's judgment.
Application.
Lordship, because my lord, while the decree was being settled before the learned master, these errors had come up, typographical errors. We were advised to make a short application before my lord. It is my lord's judgment of January last year, Lordship.
Last year?
Lordship, we are...
After 1 year, I will not accept.
Lordship, but ever since then, my lord, the matter was being taken up before the master.
You continue with the department. What can be done? Now, January 24 judgment, you now want correction in September 29.
I humbly submit, my lord, it's an ex parte judgment, my lord.
Might be ex parte or contesting, whatever it may be.
My lord, I beseech my lord. It's a very short.
I don't know. Let the matter come. I will not fix it, man. Let your application come on list.
My lord, upon notice, I'm mentioning item number 237 of today's list for fixing a date for witness action.
237.
237.
Yes. This is for witness action.
Witness action.
Who is for the other side?
CK Jain.
Huh?
CK Jain, your lordship. CK Jain and company.
So it is case is at the stage of witness action.
Witness
you are
action.
For plaintiff.
I'm for the respondent.
Who is for the plaintiff?
CK Jain.
Whether the evidence.
Yeah, the evidence has been closed.
What is the
now
last order?
The last order, my lord, this was supposed to be returnable on 7th of August.
7th August, 2 p.m.
Then your lordship was not sitting on that day. However,
witness can be produced and clicked. So other is now, where is the other side? Have you mentioned, have you issued the notice? Where is the
yes,
notice?
This is the notice, urgent. Your lordship, the clerk of CK Jain is available. I think the learned advocate.
The court cannot address the clerk.
The learned advocate must be in different court.
Record an order. Learned counsel for the defendant has mentioned the matter and submits that item number 237. Learned counsel for the mentioned the matter submits that by an order dated 12th June 2025, this court fixed the matter on 7th August. This court had fixed the matter on 7th August 2025 at 2 p.m. But on the said date, this court was not available. But on the said date, the court was not available. Thus, the matter could not be taken up for hearing. Accordingly, she prays for fixing another date and time so that the witness can be examined. In view of the submission made by the counsel for the defendant, let the matter appear on 25th November 2025 at 2 p.m. The counsel for the defendant is directed to inform the date to the learned counsel appearing for the plaintiff for their information.
Lordship, permitted one mentioning, Lordship. Lordship, the matter is company
Yes.
matters inclusion. Lordship, the matter is pending since more than 5 years. Lordship,
I can't hear you, madam.
Lordship, kindly, the matter is pending since more than 5 years.
For
Lordship,
what?
Lordship, kindly inclusion the company
For
matter.
what?
Lordship, applicants is
So why you not come yesterday? Company matter is taken on Wednesday. Come on Wednesday at 2 p.m. Correct.
Lordship, it's not in the list, it's for inclusion.
Well, that's why you come on that day, because now I will take where I will give the list. Come on Wednesday at 2 p.m. mention, I will see that.
Well, may I be permitted to mention a matter, my lord? My lord, as I indicated on the last occasion, also last day, my lord, I have mentioned this. The defects were rectified, my lord. Accordingly, my lord, as it has fallen from your lordship that summons were issued or not, my lord, it has been issued. Till date, my lord, no Vakalatnam has been filed on behalf of the
Where is the report?
defendants. Well, this is the report, your lordship. 20, my lord. Kindly pardons the, my lord, printout. Little illegible, your lordship, but if my lord kindly sees the next page, my lord, this is the sheriff's report.
Neither the original nor the service report has been received by this office. Item delivered to addressee on 16/6.
My lord.
At the request of the 16/6.
Yes, your lordship.
Yes. So what do you want?
Only, my lord, inclusion, my lord, kindly includes the matter, my lord.
120 days is not over.
Yes,
Come after 120 days.
200.
Come after 120 days. If it is none, because today I cannot fix for any unless it is 120 days.
Very well, your lordship. I'll come back. So grateful. Thank you.
I appear for the defendant number 2 in this suit.
Appear for the plaintiff, my lord. My witness was examined and cross-examined on commission. It is over. Mr. Ghosh, I am the commissioner. My lord, the last extension was up to 27th of August. That was on 10th of July. My lord had passed that order, or Justice Mojumdar had passed it.
Yes.
And it's completed. It's just time to file the report.
Me a week's time or 2 weeks time, I'll file the report. It's ready. It's all.
14th August, your lordship, the cross-examination was completed by me. 14th
Plaintiff
August.
is over. We have no
Defendant,
witnesses.
there was no direction.
There's no direction. Mr. Banerjee is
The
appeared.
defendant witness has to be examined and cross-examined now in court, your lordship.
So
Then let there be a direction. Then he'll file his affidavit.
also
evidence.
examine through the commission. Let the
No, lordship, we want to do it through the court, your lordship. That's the instruction. We want to do it through the court.
Let them do it.
No,
through
only we have to file our
Let them file
our
that
affidavit in chief. Then Mr. Ghosh will cross-examine my witness.
It is better to go with the commissioner, but plaintiff witness has been done by the commissioner. So defendant
Your
witness.
lordship, I have no difficulty. It is only the instructions which I have got through my client. I have personally no difficulty. We want to do it before Mr. Ghosh. I have no difficulty. But only the instructions of the client that I am conveying before this court, your lordship.
Can you file the report?
Well, kindly grant me 2 weeks time because the witness. Well, only one thing, because the witness is not in Calcutta. He has to sign the deposition. That is all. It's an extensive cross-examination around
Then,
7.
your lordship, kindly keep it after vacation.
In that
Kindly
case,
keep it
no,
after
no.
vacation.
After
Yes.
2 weeks, you come with the report.
Yes,
then
yes.
I'll direct because
Yes,
that
my lord.
process is to be completed.
Yes.
Yes, my lord.
Correct.
Because the witness,
I'll
I'm told he's supposed to come in the next week. So I'll have him sign it in the next week.
So once he file, your lordship, then your lordship will give me the direction. We will file it in the time your lordship gives us.
The plaintiff submits that. Plaintiff witness has been examined before the commission and he will not adduce any further evidence. Then an advocate commissioner submitted, though the plaintiff witness is examined in commission, but he required 2 weeks time to file report. In view of the above, let the matter appear on let the matter appear on 24th of September 2025 for filing report by the commission.
So great.
The extension has to be granted because it's up to 27th.
That is
24 September for filing report by the commission.
Yes.
Not
Under the same heading. Let the matter be listed as to be under the same heading for filing
Your
report.
lordship, for defendant number 1.
Grateful,
My
your lordship.
Because उनका record लिखा है. Naam report.
No, order.
Respond.
Yes.
This is your dependence in the suit. We are clubbing together.
Yes. Who has filed the application?
Milord, it's my application, Milord.
So where is your annexer A and annexer Z4?
Milord, annexure Z4 may not be an annexure in the plane, but annexure A, I see in the Milord that yes, annexure A.
Annexer A attached to the instant application mentioned in paragraph 13 at page number 15. Page number 15, paragraph 13, yes. On page number 15,
Yes, it is
whereas the
an order passed
annexer
on June
mentioned in this
23.
application being annexer A and annexer Z-4 are not appended. Z-4, where is that?
Milord, annexure Z4 is not pleaded or annexed with my application. Annexure
A.
A is an order passed by a lordship in this particular proceeding. So, Milord, that is not appearing in a lordship in this particular brief. So, Milord, I am not relying on this because this is an order already passed. Lordship will kindly grant me leave to, Milord, pen through this particular averment. If that is not
Order is there.
Your Lordship,
yes, Milord, it's already there.
Order dated 23rd.
Yes, yes, it's there.
So why?
It is there.
ये कौन है report भेजा?
But Z, there is no Z series annexure.
Actually, my officers are very high qualified.
Your Lordship, I'm appearing for the plaintiff, and in GA number 9, I am the respondent. If they are pressing GA number 9, we would like to file an objection. I'm led by Mrs. Shuchishmita Ghosh Chatterjee. She's on legs. She's currently unable to enter, and Mr. Bose also, he's out of time. So kindly grant us the leave to file an objection.
I do not stand in the way, Milord. It is my application under section 10 of the Code of Civil Procedure. Because of the similarities in the relief sought in an earlier plaint and
So
this
what is your
particular
prayer?
Milord, for stay of operation of
Section
this
9,
particular
section 10.
section 10.
So you file application, you file affidavit.
I want to file an affidavit and objection. Kindly grant us the leave to.
I do not stand in the way.
So in such application, you're not aware.
You are appearing for whom?
For the plaintiff in the present suit.
You are appearing for the defendant number?
I am appearing for defendant numbers 3 and 4. This is an application filed
3 and 4.
specifically by
You are
4.
41. You are appearing.
But
2.
my reliefs are not against the defendant number 1. Still, I would request my learned advocate on record to Milord,
Sir,
favor them with
sir,
the
the
copy.
copy.
Yes, I would definitely do that.
But I could not understand what is this report.
Milord, the annexure A is there, as I can see. That is the only annexure, Milord, because all the other things are, Milord, I will be relying on the plaint which is already there in a lordship's record. Yes.
The matrix list is to be mentioned on receipt of the report from the central filing section. जरा इसको बुलाना है फाइल का साथ. Filing section. Full stop. It is fine from the record. A report. In the report, it is mentioned that annexer A attached to the instant application mentioned in paragraph number 13 at page number 15, whereas the other annexers mentioned in the application being annexer A and annexer Z4 are not appended with this application.
লিখতে ভুল হয়েছে এর টু না করে দেড় টু হবে
No,
Milord, may I clarify?
Come to paragraph.
Paragraph 8.
F.
Page 8.
Page 6, paragraph F.
Yes. Well, several places.
Yes, layout. Then
This is from this is Milord.
I am not passing any order.
There is some errors.
I am not passing any order. There is some confusion in the report and
Milord will kindly see.
So where is your Z4?
Milord will kindly come to page 4.
Page 4, yes.
This is the prayers which I have set out from Milord, which is sought for in the earlier suit. So this is a set out of the prayers. This is a
quotation of the prayers.
Declared as acha, shown as the layout plan being annexer A, A2.
So this is quotation from the plain. This is quotation. So this is not an annexure over here. This must be an annexure in their place.
क्या बोला?
प्रॉब्लम डिपार्टमेंट के
लास्ट में क्या बोला? Are not appended with this application.
এখানে annexure এই আছে, ওটা নাকি negative দলে পাইলে আছে।
Counsel for the defendant, defendant number
Defendant number 4.
defendant number 4 who filed the present application submit that the annexer A is enclosed with this application being page 17 and 18. That is the order passed by this court dated June 23rd, 2025. Full stop. As regard the annexer Z4, it is not the annexer, it is the set out of the prayer portion of the main plaint. Considering the submission made by the counsel for the defendant number 4 and considering the pleadings, this court find that the defendant number 4 has not annexed the annexer being Z4 and annexer A is already on record being at page number 17 and 18. 17 and 18. Thus the department is directed. So why ये क्यों आई ये सेंटर फाइलिंग क्यों इस तरह किया? तो नंबर भी दे दिया, सेंटर फाइलिंग का क्या काम?
For office report.
The department directed to file the set and to place before this court for further consideration. Full stop. Have you served the counsel for the defendant number 4 is directed to serve the copy of this application to all the parties within 2 days from this.
Within 1 day, Miller. The rest, because the main contesting party, that is the plaintiff.
Within 2 days, let full stop. Affidavit in opposition be filed by
3 weeks, my lord.
by 3 weeks. Reply if any.
2 weeks.
2 weeks.
Automatically
As it is that side.
2 weeks. This is the matter on 11th November.
One humble submission.
I am appearing on behalf of defendant number 7 CAC, my lord. I pay leave to appear online.
Yes, no problem.
Miller, your lordship, Miller, has dictated. This is a prayer in the main suit, Z4. It is prayer in CS 121 of 2020. Earlier.
Prayer in the main suit बोला है ना? Z4 is the prayer of the CS number
121 of 2020.
121 of
2020.
Which is renumbered now. Which is renumbered.
But that was the original number.
Yes.
Oh, thank you.
Keep obliged, Miller. Anyway.
I'm grateful, my lord. I'm grateful.
Yes, what is the correction?
What I've done for Lordship's convenience, proposed corrections, my lord, I have made it. Kindly see, my lord, paragraph 5. Lordship is taking the proposed correction. My lord, Lordship had directed page 2, paragraph 5, around 5th line, by referring to the said clause, where a counsel for the petition submits. AMC tax is not included in monthly rent, and the defendant has to pay the monthly rent in excess of Kolkata municipal rates and taxes. It should be not in excess of that.
क्या चीज? Has to pay the monthly rent in excess to the agreed monthly rent.
It should be Kolkata municipal taxes. So, Dr. You can see the draft, proposed draft. I've handed over.
It's not included in the monthly rent and the defendant has to pay the monthly rent
In excess of the Kolkata municipal tax. This was us.
but in what is mentioned in the agreement? Yes, show me the agreement.
Not 7.
Letish shall be paying municipal taxes or any other taxes and taxes levied in.
All other inputs.
Yes. What the court has passed.
Lordship has observed will be rent in addition to rent.
By referring the said clause, London Council for the apprentice submits the KMC taxes is not included in the monthly rent, and the defendant has to pay the rent in excess to the agreed monthly rent.
In excess?
So what is the difficulty?
Well, what's the problem?
No, no.
Defendant has to pay in excess to the monthly rent. Monthly rent in excess of monthly rent, Lordship has said. It has monthly rent in excess of the taxes. And it says KMC is not included in the monthly rent, and the defendant has to pay monthly rent in excess to the agreed monthly rent, in excess to the agreed KMC taxes. But monthly rent has been repeated twice. The rent has to be paid in addition to taxes.
Yeah, then
Then Lordship gave them 12 installments for the arrears and future rents to be paid month by month as occupation charges. But para 9, Lordship will kindly come to. But no date has been fixed.
yes, according to defendant, I have to pay the arrears of monthly rent at the rate of itna from month of September till 2020 till the month of September 2020.
From the month of 2020.
Yes, till
August
2025 in 12 installments.
From on and from, it's not mentioned.
From the month of September, kindly read, sir. Accordingly, defendant is directed to pay the arrears of monthly rent at the rate of 1,24,000 from the month of September 2020 till the August 2025 in 12 installment, and the defendant is also directed to pay the occupational charges. Occupational charges from September implied. Sorry.
And the last one is, my lord, the statutory charges, TDS and GST.
GST that has to be deducted.
That I will not. What are you pass on your pass?
My lord, one more thing, my lord, in paragraph 3, my lord, it has been observed by your lordship that the rent, my lord, that is inclusive of the corporation taxes, but that is not, my lord, that is excessive of the corporation taxes is excessive, my lord. My lord, that would be your lordship.
Yes.
Paragraph 3, my lord. Paragraph 3, my lord, if your lordship comes to page.
You have not mentioned this matter, it is mentioned by the other party.
That is clause 5, my lord.
The
GST taxes in excess of.
The matter is listed to be mentioned on the prayer made by the counsel for the plaintiff for correction in the order dated 25th of August 2025. Counsel for the plaintiff submitted in paragraph 5, page 3, paragraph 5, page 3, first line, after the word monthly rent and monthly rent. No, after the word in excess, the word is to be incorporated. In excess, Kolkata Municipal Corporation taxes and other taxes in addition to ठीक है क्या बोला in paragraph 5 after the word in excess and before the word to is to be added Kolkata Municipal Corporation taxes and other taxes in addition. ठीक है? Is to be incorporated. In view of the above, in paragraph 5, page 3, first line, shall be read that the defendant shall be read that the third line after the word excess and before the word to The word shall be read as Kolkata Municipal Corporation taxes and other taxes in addition. The said word shall be incorporated in the order dated 25th of
My
August
lord, may I submit one more thing, my lord?
2020.
My lord, may I submit one more thing, my lord? The other two applications which I have filed, my lord, that is also appearing in the list and the to be mentioned, my lord. Kindly fix up a date, my
Which
lord.
matter?
My lord, in this matter only, my lord, GF 4 and 5, my lord.
Ah.
They are my applications, my lord. They are coming for
Have
the.
you served?
Yes, my lord.
Affidavit completed.
Yes, no, my lord. First time, my lord.
The counsel for the defendants submitted. The defendants have filed an application being GACOM 4 of 2025 and GACOM 5 of 2025. For what?
My lord, GF 4 is for repairing, my lord, and GF 5 is for my lord, repairing of the premises, my lord, and GF 5 is, my lord, a recalling of your lordship order, my lord. There are some typographical errors in the order, my lord, for
Which
correction.
order? This order?
No, my lord, another order, my lord.
For recalling of the order passed by 5 for repair of the premises in question and for recalling of the order passed by this court dated.
My lord, your lordship's order dated, my lord.
Dated. The counsel for the plaintiff prays for time to file affidavit in opposition. That
But
affidavit is filed by
1 week of
week after vacation. Reply there to be filed within a week thereafter. List the matter on 19th November.
My lord, one more thing, my lord, for the repairing part, my lord, opposition, my lord, it will not serve the purpose, my lord, if your lordship appoints a special officer.
That at the time of hearing, I will
My lord,
see.
because, my lord,
If they have objection, they are admitting, then the question of does not arise. If they will deny, then the court will see.
my lord, because, my lord, we cannot use the premises at all, my
Correct,
lord.
madam. Now, if they will object,
And
then only the court will. There is no application with regard to the commissioner.
no, my lord, not that.
Huh?
19th May, the 20th.
Okay, then continue.
My lord, I have already bought the occupational charges for the month of September, my lord. The check is dated 10th, my lord. 10th of September. May I hand over to the, if your lordship.
You to the party by letter.
As your lordship, please.
I appear on behalf of
Appear for the decree holder.
I appear on behalf of the judgment debtor, Your Lordship. May I file my affidavit of assets? Your Lordship.
Affidavit of
Assets. This is an execution application. There was the
Lordship had passed an order of
warrant of arrest.
warrant of arrest. Milord, subsequently, yesterday the matter came up. Milord, they said that they will file it.
Your Lordship's order dated 18th of August.
So what has happened? The
Lordship,
warrant issued.
No, Your Lordship, the warrant could not be issued because the judgment debtor is a company. So a warrant could not have been issued. So, Your Lordship, it was mentioned by my learned friend. It was kept yesterday when I submitted before Your Lordship that I'll be filing the affidavit of assets. So Your Lordship was pleased to keep it today for filing of the affidavit of
This is
assets.
in terms of, not in terms of the rules.
It doesn't seem to be, Milord. That is what.
Lordship, if not in
Give the CPC. I am not accepting without the rule.
Not even particulars, Milord. We have come.
Correct. I have seen. That's what I'm telling. It's a specific format is there.
Will it be Your Lordship's pleasure to allow me to replace this affidavit of assets?
From July, Milord, they are
I'll not
file
take
this.
If Your Lordship will Will it be your lordship's pleasure to allow me to replace this affidavit of assets in that event?
But in the meantime, my lord, we have come to be aware they have, my lord, I may say willfully, my lord, suppressed. There is one immovable property which they have.
जिसमें एग्जीक्यूशन का रिपोर्ट वो ऑर्डर नहीं रखते आप लोग तो कुछ रखते ही नहीं yes
At page 3, my lord, of the affidavit of asset, they have said that I have an immovable property in my name which is secured with creditors. Lord, they have not given the details. We have found the details on Sarsai, my lord. Lord,
that's what I'm telling that's
yes, my lord.
what I'm telling.
I'm praying for.
अरे ऑर्डर में किया था कंटेम्प्ट में कहाँ ऑर्डर जिसमें
Lordship, I believe Mr. Banerjee was appearing, Rohit Banerjee was appearing in that matter.
इसमें पिन वो भी करके रखा था वो भी मोड़ के रखा था वो भी नहीं है so how soon you will file affidavit
Your Lordship, 7 days.
so you are not disclosed this document
Lordship, it stated, I admit, Lordship, it stated that it was secured by creditors, but that document is not disclosed.
It appears that my lord, there is no amount lying in their bank account. So, my lord, the order previously passed.
that's why I find in all affidavits similar things
yes,
judgment debtors are coming
my lord, that is why, my lord, I was praying
where
for the
is the
attachment.
statement you have this is statement is correct and true you are not suppress any material fact where is that where is that you are not suppress any material fact
So paragraph 12 only states that the statements are true to my knowledge.
my knowledge you are not suppress any material fact
That is not there, Your
then
Lordship.
and these statements are true
Lord, may I pray for a further order for attachment of this property, my lord?
let they come the judgment debtor by an order dated 18th August 2025 this court has passed an order for issuance of warrant against the judgment debtor now the judgment debtor has appeared and submit that the judgment debtor is a company and as such he may be allowed to file the affidavit of assets the responsible officer of the judgment debtor that is a company may be allowed to file the affidavit of assets the judgment debtor company has filed the affidavit of asset but this court find that is not in accordance with law accordingly the judgment debtor is directed to file a fresh affidavit of assets in accordance with law by affirming by declaring that the statement made by the judgment debtor are true and correct and has not suppressed any material fact in the said affidavit. Let this affidavit of asset be filed within a week. List the matter on on 12 September 2020. The affidavit of asset filed today be kept with the record.
Keep
I appear for the plaintiff, Your Lordship. Lordship kindly sees the order dated 2nd September.
I appear for the defendant, my lord.
2nd September 2025. Your Lordship, we have been granted some time for curing of the defects. However, it is recorded that the plaintiff to rectify defects till 9th August 2025, Your Lordship. Kindly.
By an order dated 2nd September 2025, this court has allowed the plaintiff to rectify the defects. But the date has been wrongly inadvertently recorded as 9th August 2025 instead of 9th September 2025. In the order dated 2nd September 2025 at paragraph 4, line number 2, the date shall be read as 9th September 2025 instead of 9th August 2025.
Obliged.
Yes.
Yes.
Lordship, I am for defendant number 2 and 3.
Yes.
Lordship, I am led by Mr. Banerjee, Ratnako Banerjee. He is not in town. So is Rutuji Sarkar. They are in Delhi.
Huh?
They are in Delhi.
Huh.
So suddenly this matter came up. It was last in the list of. It was last in the list of adjourned motion. It is in the first. So my lord can keep it on next Tuesday or Monday or Tuesday, whichever day, my lord.
I mentioned this matter yesterday.
That's
Is
why I
also
kept it.
yes. My lord, I will complete. I was arguing on GA1 and I had more or less completed my arguments. I am to place the judgments. They can reply on the next day.
You take note of it.
That last occasion also Mr. Banerjee was not there.
I appear for defendant numbers 4 and 5. My lord, we've affirmed our affidavit in opposition. We've also served upon the plaintiff. My lord, we've also served upon the plaintiff our affidavit in opposition to GA 1. Now that's very, I filed that opposition. But I don't believe any reply has been used against this
opposition.
Affidavit in opposition.
GA1.
GA1, your lordship is considering.
It is ad interim is going on.
No, my lord, it is after affidavit. Final after affidavit, my lord, they have filed very belatedly. I didn't want to upset the hearings, my lord, by filing a reply. Your lordship will kindly proceed on the basis that I have denied allegations. Allegations are not deemed to have been admitted, and we can proceed, my lord. I will suffer whatever happens. If I don't get a relief against 4 and 5, I will suffer that, my lord. 1 has filed, and 4 and 5 is more or less as 1. So I will take that risk, my lord. Your lordship will kindly only record that I did not intend to. Allegations made in the affidavit are not admitted, and I wish to proceed.
I apologize, my lord, with deepest of respect to my learned senior friend. When an direction has been passed for exchange of affidavits, but by way of oral submission, they cannot be denied. If I am filing an affidavit, if they don't want to file an affidavit in reply, that's perfectly fine. But it cannot be deemed to be denied. But once directions are humbly, my lord.
When the direction was passed?
Yes.
The directions were passed, we filed it, my lord.
Yes.
Lord, we
Long
affirmed
after.
it. We've affirmed it on 21st
When the
July.
direction was passed for affidavit?
The orders of the directions were passed much prior. We've affirmed it on 16 June. The affidavit has been affirmed on 16 June, my lord.
I am asking the direction. When the direction was passed for affidavit, sir?
Where are the orders, Sneha?
Lord, 23rd June also an order is passed.
First directions were passed in the month of May.
Position. Yes, month of May. And thereafter 10th June. 10 June also, my lord. Yes, my lord. My lord, 10 June order, my lord, will kindly consider. 10 June order, my lord, directs us to file an affidavit in opposition by 16 June. We have affirmed by 16 June. We are within time. 16 July, I'm sorry. 1 month delay.
1 month delay only.
I'm sorry.
There's a 1 month delay only. No
There is
prayer
a-
for extension
I'm
sought
praying-
after hearing had commenced.
My lord, I'm praying
Kindly
for
do
that
not take it on
extension.
record.
16 July, I have affirmed and also served my learned senior
Kindly do not take it on record. After 3 extensions, they walk in when they want to walk in after 1 month. I've never heard such submissions that you cannot deny orally if you don't wish to file a reply. But if he takes this stand, then do not take the affidavit in reply. Kindly see the first order in the month of May, then extension, 3 extensions granted. Sir,
My lord will kindly
20th May 25, your lordship sees is the first order. First order of 20th May 2025, affidavit in opposition be filed within a week from date. So it should have been filed on 27th May. I was to file reply, the matter was to be taken up immediately after reopening. Then, my lord, kindly see the second extension. 23rd, 10th of June.
Yes.
23rd.
And then, my lord, 23rd June, third extension. Let affidavit in opposition be filed by 1st July. They walk in on 16th of July. This is not a path that you come whenever you want.
Well, 16 July also, my lord, time was taken for exchange of affidavits. I admit that I had not sought time, my lord. I admit this. I am not saying anything
Affidavit
that
in reply be filed
had
by
some-
tomorrow, 17 July.
I
By
have
tomorrow, 1 day's time was given. Kindly see 16 July order.
on that same day I had served also upon my learned senior friend my
You are
affidavit in
appearing for
opposition.
whom?
Defendant numbers 4 and 5.
Okay,
On the same day.
kindly
Yes,
come to the 23rd June.
23rd June, my lord.
Yes.
Yes, my lord. 23rd June.
23rd June, page 2, paragraph 5.
Yes, my lord. Paragraph
Defendant
5.
prays for time for extension of
Yes, my
plaintiff
lord.
affidavit. Let the opinion of
Yes.
filed by 1st July.
Yes, my lord.
Reply by 10th July.
My lord.
Correct.
My lord.
Now come to the 1st July.
1st June, my lord. No, 16 July order.
16 July. 1st July, there
16
is
July.
nothing.
Yes, my lord.
Counsel for the plaintiff prays for time, we file reply. Affidavit reply, we file tomorrow after serving the copy to solicitor.
Yes, my lord.
You are not paid for any extension.
No, I didn't appear that.
Then
On
I
this day also, my lord, they
absolutely
did not appear.
I
hearing
absolutely admit.
started.
I
Hearing is started.
absolutely admit, my lord.
Then
I only pray this. I'm not saying
No,
anything,
I
my
will
lord,
not-
as to
I
my
will not accept.
conduct. Only one prayer, my lord, if my lord kindly considers
I
on
will
that
not
same day.
accept.
On the same day we have served. We have served
You
a
might
copy of the
accept,
affidavit.
but you are not taken extension on 16
Absolutely,
July.
absolutely,
After
my lord.
1st July, you are not taken
My
extension.
lord, absolutely. I bow down.
You can
I
say-
bow down. I
Then
bow down.
Then thereafter, the matter was taken on 16 July.
Yes,
16
my lord.
July, you are not taken.
They did not even appear.
We
Then
didn't appear. We were not
22nd July,
represented.
nothing. Then 22nd July, it was placed.
My lord, kindly do not take the affidavit.
My lord,
My lord, it is a stand that I
it is
cannot.
my
Oral denial is not
I only
acceptable. Then
pray. My lord, it's only
Before
my prayer.
making the submission before the court, please see your caller.
Absolutely, my lord. My conduct is
That
not
put
ideal.
allegation upon the other.
No. I'm only saying this, my lord.
That's why
I'm
I will not allow
I'm
for your
sorry.
conduct.
My lord, I had served much prior. If my lord kindly considers, only if the affidavit in opposition
No.
could be taken
Yes.
on record.
my lord, may I just kindly have the affidavit in opposition filed by defendant numbers 2 and 3, please, my lord. I had completed my submissions, my lord, on the pleadings. Now there is just one thing which I must show your lordship, my lord, the order of the Supreme Court and how this cannot come in my way of the release which I seek over here. Kindly have, my lord, it is annexed to the affidavit in opposition of D2 and D3 at page 27.
Upon by Jagdish Sharda.
Yes, please, my lord, Jagdish Sharda.
Page paragraph.
Page 27, please, my lord. Because they rely on the order of the Supreme Court that we are entitled to receive the money, and now I cannot seek relief. Perhaps that is what they will argue. That is why they've annexed this document.
Yes.
Lordships have page 27, please, my lord.
Yes.
Kindly see, my lord, one, the proceedings, this special leave petition arises from, my lord, the dismissal of the section 37 filed by the respondent number 1. Now, my lord, kindly see the date of this order is of 9th of May. Now, my lord, I am not party to these proceedings. As on 9th of May, my suit is not there. The Supreme Court is not aware that I also have a claim.
Yes.
All three, my lord, none of these three facts are before the Honorable Supreme Court. Now, kindly see what the Supreme Court says. Kindly turn to page 28. We are informed, your lordship has that, no? We are informed. The appeal was admitted, my lord, your lordship will see.
Yes.
Appeal admitted. Now, we are informed that the awarded amount, including interest, has been already deposited with the High Court. We permit the first respondent to withdraw the principal amount, that is rupees 19 crores 92 lakhs. The remaining amount shall remain invested by the High Court in a fixed deposit. So about 8 crores was the interest, went 19 crores, he is allowed to withdraw. Now, my lord, so I was neither party, nor was my suit filed, nor was the Supreme Court aware that I have a claim. Now, even if I take their argument to the highest, that any order which your lordship may pass may go contrary to the Supreme Court order, with the greatest of respect, it does not. Number 2, my lord, the effect of this order is that he gets the money. The MOU provides that immediately when he gets the money, he has to pay back to me. That is clause 9 of the MOU. So, my lord, now that he has got the money, he is under an obligation to give the money to me.
So, in terms of this, respondent number 2.
Respondent number 2 has got the money.
Got the money. Now, who is here? The defendant number 2.
He is defendant number 2 here.
Defendant number.
And, my lord, clause 9 of the MOU, kindly see once, please. I'm sorry, I'm troubling you.
Yes, that is the
Clause 9 of the MOU squarely says that once he gets the money, he has to pay me immediately and not before that. Page 80,
84.
84, please, my lord. The transferee shall be entitled to refund of the entire money until then paid by the transferee to the transferor immediately upon the transferor receiving the same from the present shareholders or the company, as the case may be. So this is now the event which has happened. Post the order of the Honorable Supreme Court, he has withdrawn the money, albeit during the pendency of the suit, knowing fully well that I am claiming this money, he has gone and withdrawn. Now that he has received the money from the present shareholders of the company, he is obligated to refund the money to me. So the Supreme Court order, my lord, does not, with the greatest of respect, in any manner impede any of the reliefs which I seek here. Now, my lord, what I have sought is, you'll kindly see the reliefs in this application. The reliefs are in the nature of Order 38, Rule 5, my lord, and Order 39, Rule 1B. And I have sought, my lord, in that, can you just see one prayer C, please, my lord? Because now this is the prayer B and C injunction.
They have withdrawn the amount.
They have withdrawn 19 crores.
In terms of the Supreme Court order.
In terms of the Supreme Court order, they withdrawn after my suit was filed and when the parties were in mediation. They have withdrawn. Now, my lord, kindly see C. In the event that the respondent numbers one.
If this my amount is withdrawn, so what about the case filed by the defendant number 1 against you? He stated that.
So he says I have paid the money in court.
That's why I'm telling.
Full and final.
What would be effect of that suit?
My lord, that will say that now that he has paid the money, he is no longer liable to me. That is the decree he is seeking. I am grateful, my lord. Kindly see the reliefs claimed in that plaint once. The plaint is also annexed.
Because when I was considering that prayer,
yes.
That.
Your lordship had seen that. I'm so grateful, my lord. Kindly have page 232 once. Kindly have page 232 once, my lord. In volume 2. And kindly have the reliefs which he claims, which D1 claims.
That's why I'm telling a decree declaring that the plaintiffs are
discharged all liability.
So he has deposited the amount and he is telling the discharge and 6 crore 57 lakh 90,000 should be withdrawn together with the interest.
Yes. So that is now subject matter of
now that. That's the subject matter of Supreme Court.
Yes. So prayer A, he's seeking a declaration that he doesn't have to pay me because he has deposited money in court. My good friend respondent number 2 withdraws the money and goes away.
Correct.
I am left high and dry. This is my money. 6 crores 6 crores 57 lakhs I paid to respondent number 1 myself. 4 crores odd I paid to him. All figures admitted. Your lordship has seen the pleadings also. No denial that these figures have been paid.
Yes.
So I am left, my lord, high and dry. Now, in these circumstances, my lord, when I filed the suit initially and the interim application, I had contemplated that I might be late and he might succeed in withdrawing the money. So I said, prayer C, in the event that the respondent numbers 1 and 2 have already withdrawn the sums deposited in this honorable court, injunction be made restraining the said respondents from operating their bank account without keeping aside a sum of rupees 51 crores, which is my entire money claim, basically. My lord, I cannot claim security for damages at this stage. So I restrict my claim to, my lord, 26 crores, which is in prayer B, that is a principal plus interest. Now, my lord, I have taken I have filed a supplementary affidavit where I have prayed for a mandatory injunction directing them to bring back this money into court, which is also covered by, my lord, furnishing security, prayer A. Your lordship sees prayer A. Why I say this, my lord, is because from the balance sheet of the respondent number 2, it would appear that it has many creditors. Now, if one IBC application is filed and it is admitted, the money lying in his bank account will be attached. I will have no recourse. My suit will be stayed. The money lying in this bank account will be attached. I will lose the money. The court will be deprived of the security. So therefore, my lord, I have taken out a supplementary affidavit where it's already covered by A, which is directing him to furnish security. That is the relief I seek, my lord. Please direct respondent number 2 to furnish the security in court, and otherwise, my lord, or otherwise, alternatively, my lord, put in this amount which he has withdrawn. That is in my supplementary affidavit. My lord, kindly have. Because this position has been brought about during the pendency of the suit. Kindly have my supplementary affidavit. Second supplementary dated of Utsav Agarwal. My lord, it's a very short affidavit. 15 July, your lordship has, my lord. It's a very short affidavit. 15 July, Utsav Agarwal. Supplementary affidavit of Utsav Agarwal. Look at this. कैसे लिखा हुआ है? Page 9 is, yes. My lord, kindly have, my lord. Paragraph 8 onwards, please.
Yes.
I'm sorry, paragraph 6 onwards. Come. Paragraph 6, my lord, I record that no affidavits were filed.
Paragraph 6.
At page 6. I record the narration, my lord. Why I'm troubling your lordship is this. Your lordship will see from how this matter has been proceeded that at every stage, the respondent number 2 has sought to delay the proceeding. First, he did not file the affidavit. Then he came up with an application for clause revocation of 12A. Then he came out with an application under section 8. So these facts, my lord, I've narrated in paragraph 6 and 7. Then kindly see paragraph 8. I say that the petitioner has been informed that during the pendency of the mediation proceedings, respondent number 2 has withdrawn the entire amount of 19 crores 92 lakhs deposited by the respondent number 1 in this court. I say that the respondent number 2 has made its intention clear that it will not return the principal sum of rupees 11 crores 24 lakhs receivable by the petitioner. The petitioner reasonably apprehends that the respondent number 2 has already siphoned off the entire amount of 19 crores 92. This is a fit case for issuing a mandatory injunction directing respondent number 2 to deposit the entire amount withdrawn by it from this honorable court. It appears that the respondent number 2 has debts and liabilities in excess of rupees 31 crores. This is his balance sheet. Even if the amount of rupees 19 crores, that is approximately 20 crores, has not been siphoned off and is still available in the bank account of the respondent number 2, an order of injunction restraining R2 from operating its bank account without keeping aside this amount may not suffice, as there is every possibility of corporate insolvency resolution proceedings being instituted against R2 under the IBC. Out of the sum of rupees 11 crores deposited by R1 in this honorable court and withdrawn by the respondent number 2, this should be, my lord, 19 crores, my lord, not 11, I'm sorry, my lord, have been 19 crores. Rupees 6 crores 57 lakhs has been paid by the petitioner directly to the respondent numbers 1 and 8 to 19, and rupees 4 crores 66 has been paid by the petitioner to the respondent number 2 for payment to the respondent number 1. This is very important. The respondent number 2 has not paid the sum of rupees 11 crores 24 lakhs or any part thereof, but has wrongfully withdrawn and appropriated this amount. So out of the 19 crores which he has withdrawn,
Respondent number 2 has not paid the sum of
rupees 11 crores 24 lakhs or any part thereof, but has wrongfully withdrawn. Why I say this, my lord, is 6 crores 57 lakhs I paid directly to R1, which R1 has admitted in the balance sheet and on pleadings. 4 crores 66 lakhs I have paid to R2, which he has in turn paid to R1. So out of that 19 crores which R1 has deposited, 11 crores is actually my money. His money is only 8 crores. That is why, my lord, I say that respondent number 2 has not paid the sum of rupees 11 crores 24 lakhs. But he has, that 11 crores 24 lakhs forms part of 19 crores. He has withdrawn the entire 19 crores. I say that strong circumstances exist for directing R2 to deposit 11 crores 24 lakhs.
How you can say they are wrongfully withdrawn? It is Supreme Court order.
This is Supreme Court order. So, my lord, even if he has withdrawn, during the pendency of the suit, if somebody withdraws the money and changes the status quo, then your lordships have power. Order 38 is always there. That prayer is already there in the first. Here only.
That is correct. Order 38 and this court find that is
151.
Discretion of this court.
Yeah, 150.
But with regard to this court, how the court can observe it is wrongly.
My lord, I would say, humbly say this, my lord. Then it was when he knows that a suit has been filed and there is a claim of 11 crores, which is my money, then I would humbly submit, probity would have demanded the 11 crores he would have kept back. His conduct speaks. That is all that I am saying.
Okay.
He may have acted in terms of the liberty granted to him by the Supreme Court, but the Supreme Court was not apprised of these facts by either of these parties.
Why you not intervene in the matter?
My lord, in the Supreme Court, my lord, I don't need to, because I have the Supreme Court will not be able to grant me release of monies to me.
No, but with regard to the once the court, the amount is there, they are prayer for release. So you could have been.
No, my lord, the 37th, I was not party to that.
Correct.
I could have intervened subsequently.
Subsequently.
I was not aware when, my lord, one will file the
amount, because they have. D1 has filed an application, has filed the suit admitting your claim that you withdraw that.
Yes.
Deposited. So he has admitted your claim over there. Once
Both have
he has
admitted.
your claim there in
No,
the
my lord,
Supreme
I
Court,
was
they are taking the order from the Supreme Court to release in favor of the defendant number
correct.
2
Now,
and you are
no, my lord, the R2 had filed an execution case. I was under the impression from the execution case they will get the money. I will do this before.
Okay.
I didn't know, my lord, that in the appeal on the first day they will get a direction that you release the money.
They intervened before the execution court.
Correct. I resisted the execution.
So
I
they
intervened.
knew
My
way
learned is
back.
absolutely correct. So I
They
knew
knew
there's an
way back.
execution.
Way back they knew.
Of course, I
before
pleaded
the
that
matter
in the
went to
plain.
Supreme Court Lordship, they knew. They went before the execution court.
Yes.
They didn't get any order.
That is why I filed the suit, because the execution said you take your own steps. So I
So
came
the
up with
knowledge is
suit.
much before Lordship. I mean, I'm just
You can
trying
show
to
the knowledge in my petition. There's no suppression. You can show whatever.
Okay.
So this is the point. Now, my lord, on this, may I just show your lordship is very well aware of these judgments. Your lordship has referred to all of them, being shown these repeatedly. First is, my lord, a division bench of our court, 2019 4 CHN 412. Kindly see paragraph 50, my lord. 48, 49 and 50. There cannot be an absolute proposition that in a money claim, no order of injunction or attachment or receiver. I'm sorry, my lord, paragraphs 49 and 50. Last but one page of the report.
Yes.
There cannot be an absolute proposition that in a money claim, no order of injunction or attachment or receiver could be made. Order 38 to Order 40 of the court does not restrict the power of the court to pass any order that a court is empowered to pass just because it is a money claim. We have already discussed the circumstances. If there were doubts about exercising power under any of the aforesaid provisions, it can be safely stated that the court has inherent power to pass an order of injunction or attachment upon an unimpeachable liquidated claim being demonstrated, and upon it being established that the respondents are taking steps to improperly deny the realization of a claim. Where a huge sum of money is claimed and the plaintiff prima facie establishes such amount, he would be entitled to secure his interest, keeping in view the amount involved in the suit. See so and so. And then 39(1)(b) conditions have been applied. Kindly see 54 ones. On the basis of the aforesaid facts and circumstances, we are of the view that the interest of the plaintiff is required to be protected, more so when the defendants prima facie appear to have admitted their liability and in spite of acknowledgement of liability did not even repay the interest which according to the admission of the defendants were regularly paid. Then we find that the defendants are income, balance of convenience, etc., injunction restraining them from dealing with their properties.
Yes.
Here, my lord, they have not, their balance sheet does not show any property, and this your lordship will see. Our court, my lord, has in fact referred to inherent power before Rahul S. Shah. This is 2019. Our court has referred. Then comes, my lord, in chronologically Rahul S. Shah. 2021 6 SCC 418. Your lordship remembers the paragraph number I saw the other day. 42, and then, my lord, 42.7.
Yes.
No, my lord, then it's 2022 SCC Online Calcutta 3343. Paragraph 54, your lordship will see. For the legal proposition that orders of injunction should protect. So this is the argument. I'm so sorry. Kindly have 100 onwards, please, my lord. That was the argument.
In that there is one line.
Beg your pardon, my lord?
There was one line in this judgment. I could not
My lord.
remember. Yes, 109. There cannot be absolute provision of money claim, no auto injunction.
Yes.
109.
109. Yes, please, my lord. And this is also there, my lord, in that earlier judgment in Hurlin. Hurlin also. Division bench. Yeah. Pass over. Then 111, 112. And here, my lord, the case of fraud was noticed and the division bench, my lord, upheld.
Yes.
Paragraphs, and then your lordship will see 136, Rahul S. Shah is, I'm sorry, 135.
35.
We have already discussed the conduct of the parties. Kindly see, my lord. It's very important. 135. We have all elaborately discussed the conduct of the parties and the relevant facts which I now view justify the restoration of the interim order, as a refusal to pass any such order would cause greater hardship. The appellant has fulfilled all the cardinal tests for an interim order which now needs to be restored and was allowed to continue by the appellate court. Then Rahul S. Shah is noticed at 136, 137, and then kindly see 138. What matters is whether there is sufficient likelihood that a judgment will be obtained and it will be rendered ineffective unless the court grants an injunction. So here, 138, please, ma'am.
Yes.
What matters is whether there is sufficient likelihood that a judgment will be obtained and it will be rendered ineffective unless the court grants an injunction. This is the test, my lord. Here, there's an unimpeachable claim for a liquidated amount of 11 crores shown in banks through bank admitted. So here, my lord, kindly grant me an interim leave. Now, one judgment of your lordship, my lord, where all these decisions have been considered. I could have just cited this. This was also, my lord, in the case of a commercial contract and transactions between parties relating to share purchase, money sprayed under share purchase. Kindly come to, my lord.
Yes, this all judgments.
All these judgments have been considered, my lord. Tata Chemicals, Chunnilal, 46.
46. 45, 46.
45, 46. My lord, in this court finds a fit case, defendant numbers 2 be restrained from operating the bank account of Federal Bank by keeping aside. Here, my lord, I just seek that additional relief. Let them put this money in court. Now, my lord, it might be contended that this kind of an mandatory order cannot be granted at an interim stage.
Yes.
Now, the law, and this would be the final relief. Kindly have first, my lord, division bench judgment of our court. Where our court has held that final relief can be granted at the interim stage. There is no bar in law. Kindly have, my lord, 1998 SCC Online Calcutta 254. And this, my lord, since I'm going chronologically, and this view has now been confirmed by the Supreme Court. Now here, my lord, the difficulty, the anxiety of the court was to protect the asset because proceedings were there in the BIFR. Kindly see, my lord. The lead judgment of the judgment of the senior judge, my lord Justice Pal, as a lordship then was, the first issue pertains to the construction of section 22 of the BIFR. It was contended by the appellant that the language of section 22 must be given a wide interpretation in order to affect the object of the act. In my opinion, 22 is the moratorium, my lord, like we have a moratorium under 14 of the IBC. In my opinion, while one of the objects of the act may be to help seek revival companies to survive by affording remedial measures, the other object is to prevent companies from remedial measures, thus protection. To that extent, the creditor's rights to the assets of the company, whether movable or immovable assets. But the section does not envisage the company being revived. Kindly see, but the section does not envisage the company being revived with the assets and properties of third parties. According to the appellant, if the machineries are returned to the respondent, there could be no scheme of rehabilitation. The respondent, my lord, was the owner of the machineries there. Apart from the fact that the act does not provide for rehabilitation, the properties of third parties in the company's rehabilitation, appellant being sick itself cannot survive parasitically on the properties of others against their will. And then, my lord, the act is noticed. Kindly come to the next page now. The question of balance of convenience. The question of balance of convenience would arise if the appellant had even a prima facie right to the machines without any payment for user. There is no such right. Here, my lord, I have a prima facie right in this money. Therefore, there is no question of mere balance of convenience determining the issue. Irrespective of the inconvenience that may be caused to the appellant, in the absence of any right to the machines and equipment, the appellant cannot be permitted to remain in possession of the same or utilize the same as any part. On the other hand, because of section 22 as held by my learned brother, the respondent would not for the time being be able to claim. Kindly see, I would not, if the 22 bar kicks in and like the 44 moratorium, the respondent would not for the time being be able to claim any money from the appellant, either on account of rentals or for any loss or damage which it may suffer by reason of such non-payment of the rental by the appellant or by reason of deprivation of the user. To deprive the respondent of its machinery would be even to affect a future business and source of profit of the respondent. Therefore, even the balance of convenience in favor of the machines being returned. Two other grounds have been raised in the pleadings of the appellant, which the first is the existence of an arbitration clause. The ground is untenable. The second relates to territorial jurisdiction. So we are not concerned with territorial jurisdiction. And kindly see the other judgment of my Lord Justice Panigrahi. Kindly turn to paragraph 'Kindly give me a minute, Palak. Well, the rest deals with the appointment of receiver. I'm not paying for receiver. So this is, my Lord, where I cannot be denied the benefit of my funds. Now, my Lord, now the Supreme Court, my Lord, also seems to say, kindly see 2019-4 SCC page 1, on the ambit of a mandatory injunction at an interim stage. Kindly come to paragraph 57. And this was at the ad interim stage, ad interim mandatory was granted. We are now at the final hearing at the interim stage. Kindly see paragraph 57. The grant of mandatory injunction is not prohibited even in so-and-so. It has been held that unless clear and prima facie material justifies a finding that status quo has been altered by one of the parties, the order in mandatory injunction can be given. The ad interim mandatory injunction is to be granted not at the asking, but on strong circumstances, so that to protect the rights and interests of the parties, so as not to frustrate their rights regarding mandatory injunction. In Deoraj versus State of Maharashtra, this court held that court would grant such an interim relief only if it is satisfied that withholding of it would prick the conscience of the court and do violence to the sense of justice, resulting in injustice being perpetuated throughout the hearing, and at the end, the court would not be able to vindicate the cause of justice. So here, my Lord, if this money is not brought back, this position will be irreversible. Therefore, in appropriate cases, ad interim injunction in mandatory form can be granted. Situations emerge where the granting of an interim relief would tantamount to granting the final relief itself, and that there may be converse cases where withholding of an interim relief would tantamount to dismissal of the main petition itself. For by the time the main matter comes up for hearing, there would be nothing left to be allowed as relief to the petitioner, though all the findings may be in his favor. In such cases, the availability of a very strong prima facie case of a standard much higher than just prima facie case, the considerations of balance of convenience and irreparable injury forcefully tilting the balance of the case totally in favor of the applicant, may persuade the court to grant an interim relief, though it amounts to granting the final relief itself. Of course, such would be rare and exceptional cases. The court would grant such an interim relief only if satisfied that withholding of it would prick the conscience of the court and do violence to the sense of justice, resulting in injustice being perpetuated throughout the hearing, and at the end, the court would not be able to vindicate the cause of justice. Obviously, such would be rare cases accompanied by compelling circumstances where the injury complained of is immediate and pressing and would cause extreme hardship. The conduct of the parties shall also have to be seen, and the court may put the parties on such terms as it may be present. And here, paragraph 60, the division bench judgment was reversed. The order of the single judge was restored where it had granted an ad interim mandatory injunction.
Yes.
On legs. Now, my Lord, one more last decision on this, my Lord. It's an unreported judgment of the Supreme Court. Kindly have, my Lord, paragraph 32, where the court takes note of the conduct of litigants to delay proceedings and thereby steal a march on the other side. Kindly see paragraph 32, please, my Lord.
Yes. Yes.
The court would categorically emphasize that no litigant should have even an iota of doubt or an impression, rather a misimpression, that just because of systemic delay or the matter not being taken up by the courts resulting in a flux of time, the cause would be defeated. and the court would be rendered helpless to ensure justice to the party concerned. Here, your lordships have taken up the matter every day, but on some pretext or the other, they have delayed the hearing of GA1. First, they did not file affidavits. Then, without filing affidavits, they took out 2 applications. That is how they've concluded. It would not be out of place to mention that this court can even turn the clock back if the situation warrants such dire measures. The powers of this court, if need be, to even restore status quo ante are not in the realm of any doubt. The reliefs granted in the list is, my lord, on the subject matter of the case.
Yes.
So, my lord, your lordships have always stepped in. Here, my lord, I have more than a prima facie case. The opposition does not disclose anything. Lordship will kindly consider directing him to bring back this money in court. Those are my.
Yes.
On GA1, my lord, if GA2 is their application, section 8, if they wish to address, I can reply, they can take time, whatever they want to.
Yes.
Mr. Banerjee, would you available on the 15th, 16th, and 17th?
I see 8th and 9th also on my learned friends list. 8th, 9th, 15th, 16th, 17th.
No. 8th, I am not there, Lordship, personally. So 8th, I have to do the conference. So can we keep on 9th? Lordship, but my learned friend innocuously have said beautifully, I must say. From 2012 till 2025,
Yes,
where is
yes,
the
you will
money?
argue.
No asking.
You will
No
argue.
asking for 13 years.
So please argue if you want to argue.
Counsel for the plaintiff.
Let's not give sideways.
Argument in respect of GA1 of
That too, the court of court.
Counsel for the defend number 1, press for time. Defend number 1.
2 and 3, Lordship.
Defend number 2 and 3. Defend number 2 and 3, press for time. According case is adjourned, let the matter appear on when he will available.
His own 9th is available, 15, 16, 17 is available.
9th?
9th is available.
9th में है, देखो हमारा मैटर है।
शायद अच्छा।
आपको फिक्स है कितना बजे? टाइमिंग खाली नहीं। Fix on 9th under the heading adjourn motion.
Grateful, Manas. Deeply obliged.
The lordship has kept it on?
9th.
Nine.
9th. Grateful, Manas.
You might pay just for one input.
Because of your submission, I will not allow. If you have committed any error, plus you be sure before the court and be sure before the signers, then you make a submission. Sorry, 3 times you have taken adjournment and with the, I don't want to open the further mouth.
Grateful.
Sorry.
Lord, is your lordship fixing?
I am lenient on all this, but I will not allow this type of the practice. You committed wrong and telling before this court of wrong of the other side.
I'm not saying anything wrong.
Why?
At the top.
चीफ जस्टिस से यहाँ आने को यहाँ आने के लिए 1 दिन लगता, वही तो 1 दिन लगता। Yes, call the matter.
My lord, I was addressing your lordship on that order 13A application.
Yes.
I had, my lord, placed the documents from the, my lord, application. This was pertaining to a claim on account of, my lord, services I rendered to get hold of a, my lord, tenant Kalyan Jewellers. My lord, I had completed showing, my lord, all the documents from the, my lord, application. I just need to deal with their defense in their objection. But
Which
just
are appearing? Nobody is.
yes, my lord, they,
Yes, I am for the
my learned friend also appeared the other day. My lord, only for a quick recap before I take your lordship to the affidavit.
2nd
One
September
document.
You had appeared.
Yes, my lord.
You appeared on 2nd September.
Second. Lordship, he was
Yes,
there.
my lord. Yes, yes.
He was there. Order a record.
Okay.
My lord, kindly takes volume 2 once because this is relevant. Before I show their defense, volume 2 of the petition, my lord.
Volume 2.
Volume 2 of my application, page 197. I had shown this settlement agreement. I just need to draw my lord's attention to three portions of this agreement. 197, Lordship sees the name of the party by and amongst BP Suraj Business Combines Private Limited. That is the defendant here. Then my lord kindly comes to 198, recital D. Subsequent thereto, the first party through Mr. Vikash Murarka, being one of the director of
All
BP.
this thing I had taken note of.
Very well.
You are in page number 205. Demand.
After the demand, my lord, I had my lord instituted the suit, and thereafter, my lord, the order 13A application, because lordship had recorded that they did not file written statement within the outer limit. Right closed, challenged up to the Supreme Court. Order of your lordship has been upheld.
Correct.
Thereafter, lordship has recorded that the suit will now proceed as an undefended suit. That order is at page 208. I had shown this also last day.
Not file the written statement and the order.
Court finds that defendant has not filed written statement and outer limit of 120 days has already elapsed. In view of the above, suit be placed in the list of undefended suit. Now, my lord, kindly comes to the opposition. My lord, in the opposition, my lord, affidavit in opposition, page 3.
Opposition.
Yes, my lord, it is voluminous in 6 volumes.
Yes.
But I don't bother your lordship with the annexures except one more volume I need. But for the timing, lordship takes first volume, page 3, paragraph 5.
Yes.
My lord, my first submission, para 5, the defendant makes out a case in defense to the order 13A application. My first submission is, my lord, that after the right to file written statement is closed and the suit is undefended, my lord, there is no further opportunity for the, my lord, defendant to make out a new case in defense. My lord, the law as I understand is, my lord, in an undefended suit, my lord, he would, if I had, my lord, gone for trial, he would have only the right to cross-examine my witness for the purpose of demolishing my plaint case.
Correct.
But he could not have, my lord, set up a new case which was not there in the, because the written statement was not filed.
Correct.
And he cannot take any defense.
So once the court has fixed for undefended, why you have filed the 37?
Because, my lord, I say, in view of the, my lord, settlement agreement, there is an admission, there is no requirement of evidence, and therefore a decree.
That's why they got the opportunity to file affidavit.
I know that they got the opportunity, but this is, my lord, a legal submission. Lordship will, I'm sure lordship will consider that. But even then, my lord, if lordship considers the defense case also, I'll put it, my lord, this way. Even if your lordship considers the defense case and paragraph 5, the various sub-paragraphs, then also I will try and persuade your lordship to pass an order, my lord, in the summary form in this application. My lord, the point I'm trying to make is what you could not have done directly, indirectly, directly, you cannot do indirectly.
Once you give the chance to the what they will naturally.
They chose to, my lord, because yes, of course, I filed the application. They had a right to file an affidavit. To what extent lordship will consider that defense case is, my lord? So this is my first point. Now on merit, what they have said, my lord, kindly comes to paragraph. Paragraph 8. My lord, J, subpara J of para 5, which starts at page 6. Despite the deal with Kalyan Jewellers not having fructified, plaintiff in its capacity as property broker raised claims of brokerage against defendant. Defendant was upset with Mr. Murarka over the conduct of the plaintiff, particularly since plaintiff had been introduced to defendant by Mr. Murarka. Accordingly, Murarka was instructed to sort out the dispute with the plaintiff and ensure that no money is paid by the defendant to the plaintiff, particularly since there was no liability to pay whatsoever. Then, my lord, kindly comes to K. Defendant was hoping that Murarka would effectively deal with the plaintiff and resolve the issue without burdening the defendant with any liability. Defendant was shocked to learn that plaintiff instituted a company petition before NCLT Kolkata. Plaintiff's claim in the company petition was on account of alleged brokerage pertaining to Kalyan Jewellers. Defendant was shocked to learn about the order. Dated 10th May 2022, the company petition has been admitted. Upon perusing the records, it appeared Mr. Murarka had failed to effectively represent the defendant before the honorable tribunal, which resulted in admission of the company petition. This is their defense, my lord. Then kindly, my lord, M, subpara M. Since Mr. Murarka was responsible for the problems being faced by the defendant at the hands of the plaintiff, Mr. Murarka assured the defendant that he would personally settle all issues with the plaintiff. Kindly marks this, my lord, expression, Murarka personally will settle. That is why, my lord, I was taking your lordship through the settlement agreement. It is between, not with Murarka. It is with BP Suraj, the company, and my lord, Murarka was only acting as a representative, being the promoter director of the company. The defendant was given to understand that pursuant to assurance of Mr. Murarka given to the plaintiff to settle the matter personally without burdening the defendant financially. My lord, I received that 10 lakh not from Mr. Murarka, but from, my lord, the defendant. The company petition stood dismissed as withdrawn with a order dated so and so. My lord, after this, my lord, kindly comes to, my lord, paragraph 9 at page 11.
Yes.
My lord, I am referring from, my lord, the foot of the page, last 6 lines, starting with, it is denied that the defendant.
Yes.
It is denied that the defendant executed any settlement agreement with the plaintiff. This is their, my lord, stand. The purported settlement agreement dated 16 July 22 is denied. In any event, it appears that such settlement agreement has been entered into by Mr. Murarka with the plaintiff, wherein Mr. Murarka appears to have accepted the liability of compensating the plaintiff. Mala, twofold arguments, like I said, agreement is with the company, not Murarka. Payment made by the company, not Murarka.
Yes.
Then, my lord, after this kindly comes to, my lord, paragraph 11 at page 13. Again, the last 4 lines. My lord, page 13, my lord.
Yes.
Paragraph 11.
Yes.
Last 4 lines. Defendant was not a party to the alleged settlement, and the same is denied. Then, my lord, paragraph 12, foot of the page, last 3 lines.
Yes.
The defendant company did not execute any settlement. My lord, this is, my lord, like leading evidence which is contrary to the, my lord, documentary evidence. Defendant company did not execute any settlement. The documents in connection with NCLT case, including the purported settlement, are denied. And the last paragraph, my lord, page 14, paragraph 13. My lord, this is, my lord, from the middle of that paragraph, starting with, my lord, it is denied that there is no defense to the plaintiff's claim. Lordship has found that.
Yes, yes.
The plaintiff has failed to prove its case completely. My lord, this he is trying to deal with my claim under order 13A of the CPC.
Yes.
The plaintiff has failed to prove its case completely. It is denied that defendant has no real prospect of defending the case. It is denied that there is no reason for the claim not to be disposed of before recording oral evidence. The exercise of oral evidence will completely expose the falsity of the plaintiff's case. So, lordship, since your lordship is, my lord, hearing a order 13A application, whether the tests are satisfied on the basis of this defense which the defendant has come up with has to be considered. Now, my lord, regarding the challenge to the authority of, my lord, Mr. Murarka, I just want to show your lordship one document. Kindly comes to, my lord, their affidavit in opposition, volume 2. They have only disclosed this document. Page 156. Page 156, my lord, volume 2 of the affidavit in opposition.
Yes.
My lord, this is part of the, my lord, records before the, my lord, Ministry of Corporate Affairs. At 156, my lord sees the 4th entry. BP Suraj Business Combines Private Limited, the defendant's name.
Yes.
Then, my lord, designation is director. Date is 27 February 2016 to 16th October 2023. Now, so far as the name of the gentleman. My lord, kindly comes to, my lord, page 155. Lordship will, in caps, lordship will get the name of Mr. Vikash Murarka. It is his particulars. So, the MCA, my lord, portal contains particulars of all the companies in which Vikash Murarka was director.
Yes.
And the period for which he was a director.
Pleading they have also said 64.
Correct, pleading দেখাবো ভাবছিলাম না, এটা দরকার নেই, para 23. One more paragraph, my lord, from এটা দেখিয়ে দিই, para 23.
Yes.
One more paragraph, my lord, kindly comes to page 37 of volume 1 of the opposition. This is part of a statement of claim which they have disclosed, saying that this is they have filed this SOC against them. This SOC has been filed by the Guptas, who had some dispute with regard to this property with BP Suraj, the defendant. In that, my lord, this averment is para 23, pertinent to state that Vikas Murarka, having his DIN number so and so, is a director and authorized representative of the respondent company all along, and has executed all documents on behalf of the respondent company in connection with the aforesaid transaction with the claimants. I would have otherwise not got hold of this document, this pleading. They have in their affidavit disclosed this. And the gentleman Vikas Murarka,
yes,
has signed, the settlement agreement as the promoter director. Lordship will find from the settlement agreement itself.
Yes.
At page 201, I have already shown that. And under section 216 of the Companies Act, 269 of the Companies Act 2013, promoter has been defined. 269.
A company angle.
Section 2, subsection 69.
Section 2, subsection 6.
Yes, my lord. Section 2.
Yes.
Promoter means a person, kindly sees my lord B, who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise. So, my lord, today feigning, my lord, this, or my lord, setting up this defense that Murarka has personally, when the document speaks otherwise, according to me, my lord, there is no, this is no defense at all. My lord also sees, my lord, 2 subsection 69C. Mr. Sen wants me to, my lord, place this also. In accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. My lord, reason being that the payment was not made by Murarka. Payment was made by the company itself. It's from company's account. I get a RTGS.
Yes.
And my lord, just for the sake of completion, my lord, order 13A, my lord. Why I should not, my lord, undertake trial? Why am I entitled to, my lord, a decree in the summary form?
Yes.
My lord, first, my lord, order 13A, rule 3, grounds for summary judgment. Court may give a summary.
Yes.
Court may give a summary judgment against a plaintiff or defendant on a claim if it considers that A, I am relying upon A, the plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of successfully defending the claim, as the case may be. And my lord, procedure is prescribed in 4. Kindly takes, my lord, 4.3. Because he has chosen to file an affidavit, my lord, let me just show, my lord, sub-rule 3, sub-rule 4.3.
Yes.
The respondent may, within 30 days of the receipt of the notice of the application of summary judgment or notice of hearing, whichever is earlier, file a reply addressing the matters set forth in subclauses A to F mentioned hereunder, in addition to any other matter that the respondent may deem relevant. I have placed extensively their affidavit to show.
Which provision you
are? This is order 13A, rule 4, sub rule 3.
The respondent within 30 days the receipt of the notice, applicant summary judgment or notice hearing, filed a reply addressing the matter set forth. Yes.
Important is, my lord, 3C and E. C says reply must state the reason why there are real prospects of succeeding on the claim or defending the claim.
Yes.
As the case may be.
Yes.
And kindly also sees E, my lord. The reply must identify what further evidence will be brought on record at trial that could not be brought on record at the stage of summary judgment. So there is no written statement, no evidence. Question of my lord evidence coming in, my lord, does not even my lord arise here.
Yes.
And my lord, kindly comes to my lord rule 6. Orders that may be made by the court. My lord, I would be relying upon 6(1)(a). On an application made under this order, the court may make such order that it may deem fit in its discretion, including the following: judgment on the claim.
Yes.
And 8, my lord, provides for the power to impose costs. Right, my lord, those are my submissions.
Yes.
I just want to, my lord, I'm sorry, my lord, one more, my lord, point. Before the, my lord, NCLT, the same gentleman, Vikas Murarka, my lord, filed an affidavit in the capacity of director on the basis of a board resolution of the company. That is at page 165 and 166 of, my lord, volume 2 of my application, paragraph 1. Thank you.
Yes.
My lord, this is the latest, my lord, decision on, my lord. Because it's ex parte, my lord, you can't, my lord, lead further evidence. You can only cross-examine because it's 2025. 2025 SCC online SC 868, paragraphs 18 and 19.
Yes.
My lord, I'm placing formally 18 and 19. My lord, I'll just read out, my lord, 19. Pleadings either in plaint or a written statement constitute the plinth on which respective claims and defense of the parties to a civil suit rest. What a pleading ought to contain is provided in Order 6, Rule 2. Only material facts on which the party pleading relies for his claim or defense to succeed have to be stated without the evidence by which the pleading is to be proved. Once pleadings are complete, but the defendant is set ex parte and such order has attained finality, the defendant's rights suffer a curtailment. He cannot produce evidence in defense, and hence statements which are in the nature of factual assertions cannot be proved by leading evidence. Generally speaking, the limited right that the defendant set ex parte would have is confined to cross-examining the plaintiff's witness. Effort has to be directed towards demonstrating that they are not speaking the truth and thereby demolish the case of the plaintiff. Essentially, therefore, in such a case, the defendant has to convince the court that the case put up by the plaintiff is so false that the court ought not to accept it. However, if the defendant raises an issue on law which is traceable in the written statement, for instance, this is not applicable because no written statement, suit is barred by limitation or section 9 CPC is attracted, or if relief claimed in the suit cannot be granted for reasons disclosed, the requirement of the defendant proving such defense as raised in the written statement by leading evidence may not arise, and court may frame an issue of law and decide the same. My lord was very kind to give them that opportunity to put in an affidavit, but the affidavit has to be, my lord, restricted to show that on the basis of the plaint case or the case made out in the Order 13A application, the plaintiff is not entitled to any decree in the summary form. And this is, my lord, the dismissal order that's not in the record from your lordship's order, my lord, which was carried before the Supreme Court, the dismissal order. January 24, 2025. So there is a finality and there is a curtailment of the defendant's right in view of what is laid down in para 19 of the 2025 report, my lord, which I just now cited. My lord, those are my respectful submissions.
Thank you.
Hello, some other day.
Yeah. Yes.
Not on today, well, some other day. Because Mr. Lakmani is in the matter. He is out of station.
Counsel for the plaintiff has concluded his argument in connection with GA Com 2 of 2025. Counsel for the defendant prays for time. Case is adjourned. Let the matter appear on 11th September. Under the same heading.
May it retain its position, my lord. Right.
Item number 11.
Lord, I am for the plaintiff petitioner. my lord.
Yes.
My Lord, on the last occasion, matter came up before your lordship on 28th July 2025, my lord. There has been an imposition of cost because on that day the matter was fixed for evidence, my lord. We took the adjournment and a cost of 50,000 has been imposed. My lord, I am filing the original of the cost receipt, my lord.
Yes.
Let it be taken on record, my lord. Now, if your lordships kindly allows, I will place my applications, my lord.
What application you filed?
My lord, this is an application praying leave before this honorable court to produce some document to disclose 5 documents, out of which 5th number of document, that the 5th item we are not pressing. We are only concentrating on the item number 1 to 4, my lord. If your lordships kindly allows, my lord, prior to that.
GS7. GS7.
Yes. My lord, the affidavit in reply may be taken on record, my lord.
Affidavit filed?
Yes, yes. My lord has passed so many judgments on this applications relating to disclosure of the evidence. I will take my chance today. And today, my lord.
On the last occasion, your lordship had dismissed it and they have, after had some mercy and directed affidavits to be filed.
My lord, if your lordships kindly comes to my page 3 of my applications, my lord.
Yes.
My lord, if your lordships kindly, I'm so sorry, kindly takes up page 2. If your lordship kindly turns to page 2, it starts with paragraph 1, but that is not relevant for the purpose. My lord, paragraph 2 is there. My lord, shortly put, it is a case where a consignment was sent by a truck from Silchar to Howrah. That was the case. It was full of pan supari materials. It was there. In the road, it met with an accident. The truck fell on the gorge and the entire consignment was lost. This is the case for which,
So
if your lordships come at pay.
You are for the owner or
I am for the owner of the consignment.
consignment?
Yes.
For the owner
Yes.
of the consignment.
Yes. So, my lord, at page.
Your materials were insured.
Yes, yes. And we lodged a claim of rupees 11 crore 59 lakhs odd, my lord. We are a very small partnership company. Now, without getting the entire claim was repudiated.
Small partnership company having the 11 crore materials transported.
My lord,
to the
let me
And one of our main defense is that the stock statement is not tallying with the loss statement they have disclosed.
My lord,
huge loss, huge suparis not tallying with the stock statement filed with the insurance company. Okay.
My lord, let me explain. Kindly give me a place here. My lord, the original consignment value of 6 crore something. There is further SRCC value, which is document number, item number 5. But I won't like to press it. That cost another 6 crore or 4 crore something, my lord. And all our item added up to this 11 crore something.
Where is the document? Which document you are
Document, my lord, this is the case about. There is the documents are in. The document I am disclosing here, I will come to 3, 4, 5, which are the relevant. But I am telling in nutshell what is the exact factum of the case. So, my lord, this is something 11 crores odd, my lord. Yes, we are dying. There is no other interpretations can be that. Thereafter, the suit was filed in the year 2014, my lord, because this is relevant. 3rd September 2014. It is in paragraph 3, my lord. Then paragraph 4, my lord, I have stated everything which is on record. It is converted to the commercial suit on March 28th, March 2023. Then it was renumbered. Previously what it was, now that it has become CS Com 58 of 2024. This is paragraph 4, my lord. Now, paragraph 5, we have stated that the discovery and inspection was finally done on December 17th, 2024. And then issues were framed on 20th March 2025. And that showing the proximity of the dates. Thereafter, the dates were fixed on 17th and 5th May for recording of evidence. My lord, it is apposite to record that we have already filed the judge's brief of document also. So that is also filed and it has also been served to the other side.
Disclosing these documents.
Malad,
Disclosing this document.
No, that we cannot, because without taking leave of this honorable court, I cannot add this, and for which I have a prayer.
First thing you tell, the suit was converted by an order dated 28th of March 2020.
My lord.
Correct.
Right.
And number as 58 of 2024.
Yes.
When you file the statement of truth and affidavit of document.
My lord, thereafter, certainly thereafter, because
affidavit documents and
in the year 2023 itself, my lord, that would be so.
Affidavit document and statement of truth hai?
अरे भाई ये तो plain.
It is served to you. It is served
Yes,
to you.
yes. I think so, my lord. Because those things are complete, my lord.
ये तो 2015 का है. आफ्टर मार्च 2023 का बात. ये तो 2015 का है.
The documents which are now seeking to disclose were not referred to here.
No, it was not there. That's why I'm praying for leave.
No, the question is that once the case is transferred to the original division to the commercial division, then both the parties, because you file the plaint and in the original division there is no requirement of statement truth and the affidavit documents and all these things and admission and denial, whatever it may be. So as per the procedure, the courts grant liberty to the parties to comply with the provisions of the Commercial Court Act, that is the filing of the statement of truth, filing of the affidavit documents in terms of the Order 11, Rule 3 and Rule 4 of the CPC. Then thereafter the inspection will come and the discovery and inspection, then thereafter the affidavit of admission and denial. That's why I'm asking if whether that provision was complied with or not. If that is not been complied with, then there will be a lacuna in the procedure. So then if it is not, then how you go with the evidence and what document you will admit and what document you will not admit?
This suit was originally filed in 2014.
2014.
From
That
2014
was
to 2023, they had the time to seek inspection.
No, that is different.
Serve interrogatories.
He's telling different.
On the other side, and the truck owner is the defendant number 2. So he's a party to the suit. So
truck owner is not at all a party, my lord.
He had all the time in the world to apply to the court for an order on the party to disclose those documents, to file application for interrogatories, for inspection. From 2014 to 2023, he just slept over the matter. Only when it was transferred to the commercial suit, he woke up, filed this statement of truth. Again, it slipped from his mind that these documents are required.
No, that's when
he was preparing his affidavit of
but there is no
evidence.
statement of truth. That is the problem. We
My
have
lord,
to file
if your lordship, yes.
When?
It is with me. It was with.
It is with you.
It was filed on 2023. 26th April 2023.
Where? You kept it there, your.
Yes, my lord.
7th January 2015.
Let it be taken,
No,
my
no,
lord.
no, no.
My lord, we don't have a copy apparently.
Copy.
No, 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 no. At this stage it is. Let me see.
My lord, my lord, first of all, as my learned senior friend is submitting that defendant number 2 is not the owner of the truck. It's what? They are the transporter under whom there are several trucks running. So they are not the owner of the truck. I have said in my application that I got it from the owner of the truck. My lord, now just let me explain, my lord. Thereafter, if your lordship discuss, I will not go on to that. My lord, kindly sees that I have said that at the preparation of the affidavit of evidence as legally instructed, my lord, it is also apposite to say that there is the change of lawyers during all this course of time. And that is from their side also. It is from our side also, from the plaintiff and also of the defendant. So this thing has got a certain changes in every time. And so now that the plaintiff has been instructed legally to come with those documents. That is the case, my lord, to be very precise. And thereafter, what are the documents? One document is a no due certificate from the consignee, because when a consignment is sent through the truck, the entire letter of that consignment, the consignment copy, the amount of the consignment sent, everything accompanies with the driver of the truck, and it goes, when it reaches to the destination, it is given to the consignee. Thereafter they get it released. So that is the situation. So when the truck met with the accident, it was there that because that was a police case, so the police made a seizure, all these things. So now the no due certificate has to be given by the consignee. That for that they have, because what happens that when an order is given, when an order of consignment is given, they have to say we have not paid any amount for that, or that we have returned the amount what we have received. Because the consignment, in a case of a consignment, that the consigner sends the consignment to the consignee, and consignee takes up the matter because he purchases it. That is the case. So whether the purchase consideration was transferred or not, for that reason the consignee has to give a no due certificate that there is no due from the part of the plaintiff in this regard. Because if he has transferred that amount to the plaintiff, then the insurable interest goes to the consignee. So that's why they have given a no due certificate that we did not have any money received from the plaintiff, and that if at all for that consignment, my lord, because that is a sale. That was a sale, my lord, because
Your materials you are sending to the
consignment. I am the seller. They are the buyer.
They are the buyer.
They have given some money as advance.
Let me see. Let me understand. So they have placed the order to you, such battle net and whatever is required to be transported, to be supplied to the person who has placed the order to you. Correct. Then in terms of their order, you have managed all the materials and booked the transporter for transportation of your good from your whatever it is, Siliguri, where from it is?
Silchar to Howrah.
Howrah. Correct. Where the vehicle met with an accident?
In Assam only, in the state of Assam, in the mountains.
At the Assam only.
Yes.
Correct. So your case is that, so whether the vehicle was recovered or not? Vehicle was recovered or not?
My lord, it was not recovered. The entire consignment was lost. Now the question is, my lord, that in order to purchase that, the consignee gave a certain consideration of amount as an advance.
Correct.
So that advance amount has been returned to the consignee because the goods never reached the consignee.
Correct.
That is the no due certificate. that whatever advance that we have given, that has been returned back by the plaintiff. That is important for the case.
Which document?
My lord, this is page 7 of my application, annexure A.
Yes, yes, receive back the
The
amount.
original of this particular document was with the custody of Vishal distributor, who is the consignee. The moment he was legally instructed, the plaintiff went to that place that you have received the money, now kindly give us that. They said that this has been issued earlier, but the original is lying with us. So therefore, you take this and we are giving you that particular document. It is not that it is dated on 2025.
So where is your statement with regard to the page 7?
Page 7, my lord.
The statement with regard why you have not produced the page.
I'm saying
No
yes.
pleadings given. No pleadings.
My lord, let me see.
Yes, where is the pleading with regard to
Yes.
the paragraph? What
My
you
lord,
stated that as per your case, the page 7 document was not with you. It was with the Vikas Jain. Who
my
was
lord,
the
kindly
consignee.
comes to page 4 at the bottom, paragraph 8. I humbly submit on behalf of the petitioner that those documents were previously not in the custody of the plaintiff, but it was obtained from the consignee, being Mrs. Vishal Distributors, document A and document D. The documents referred in B and C being the letters of owner of the truck, namely Sheikh Sirajul Islam. And the copy of the account page check were obtained lately, my lord, that comes to B and C. This is A and D. I'm talking about this A. So that I have stated, it was not with us and not in the custody of the plaintiff, but it was obtained from the consignee.
When?
My lord, it was obtained. That's what I'm trying my luck, my lord, because on the last occasion also, this is nothing to be that much because my senior friend is jumping on this. But let me explain. This is a very pitiful situation for the plaintiff, my lord. They have lost everything. Now the claim has been rejected. They are on the very threshold of starvation. Their partners are also seeking that the partnership should be dissolved. That is the conditions, my lord. There is a question of sympathy also involved because somebody has to get why I am wanting all this to go deep into the root of the adjudication. That is what? To prove it documentarily. Question is why these documents were not required earlier, why it was not in the custody. They were not properly advised. My lord, that is the only thing. Because 1115, my lord, is a total discretion of this honorable court. I will show some judgments of the honorable apex court that you have relied earlier in earlier judgments, and in another case where unfortunately I was the other side on the place of my learned senior friend, and the petition was allowed. How allowed that I will also show in the same situation at the very time of the evidence, it was instructed that to get those documents and then they got those documents. Here what happens, my lord, everything was obtained orally. They went to those places and they searched the consignee and then they say, kindly give it. There is no later correspondence.
That's why you missed one line in this paragraph. And you're not catching.
I have not stated because I've got no communications, my lord. I tell very clearly.
You have created good history, good story, not history, story. But
I'm making my
but one sentence you have missed in this paragraph.
That my lord, by hand, my lord, that should have been there by hand, my lord. That I say, my lord. Otherwise, my lord,
getting better and better.
My lord, I am trying my level best, my lord. Now that the brief is transferred, my lord, I am taking my chances to keep the relief. My lord, this is the no due certificate. If your lordships kindly comes to page 4, B, the second document. Those are very short pages, my lord. It is not voluminous. the letter to the officer in charge, Regional Transport Officer, Dakin Dinajpur, Balurghat, issued by the owner of the pertinent truck. My lord, kindly see, the name of the owner of the truck is Sirajul Islam, I have stated. My lord, kindly now, if your lordships kindly turns to the cost title, my lord would see that Road Kings Private Limited, they are the transporters. So they are not the owner of the truck. It is the owner of the truck who met with the accident, ill-fated truck. From him only, an agent of him, my lord, it took a long trouble for the plaintiff to go to that places and to get those documents out. Because they say the original has been seized by the police because those were with the in the truck itself, and that has been seized by the police. Here, my lord, we have simply stated that we met with the accident causing Sheikh Sirajul Islam along with the report of the Regional Transport Office providing report of the vehicle in the accident. My lord, kindly see page B, page 8. Page 8 and page 9, my lord. This is a document issued by the government of Meghalaya, that is the superintendent of police, my lord. That is that document. And this is to the branch manager, Bajaj Alliance General Insurance. My lords, what happens now? Let me say, because other two documents are related with this. When the truck met with the accident, it was insured by Bajaj Alliance Insurance. So they got the money for that accident, the loss in the accident, for the truck itself. Now, our insurer, being the defendant one, is also doubting the accident, that the truck never went to the gorge. That was their report of the surveyor. So in order,
And the truck over there.
just let me say. So there it would show from the very face of it that they have received the money. Had there been a situation that there was no accident, it could have been that they should have received no money. That is the case. Otherwise, the police reports, my lord, that shows that there has been an accident, these charge sheet and all, those we will produce, and those has been made as a part of the JBD. But the question is, they have also received money, the owner of the truck. And from there, it was like that, it was issued to the branch manager of the insurer of the truck itself. For the loss of the truck, they have received this money. And these two documents, along with page 10, Annexure C.
Yes.
This is, if your lordships kindly sees.
So yeah, he has received rupees 9 lakh with regard to the
Yes.
of the truck.
Yes.
Yes,
So therefore, these three documents, which per se proves that the factum of the accident is correct and true. Had there been no accident at all, there could have been no payment by the insurance company. It was paid on account of the insurance. So it is that document, and page 11. Page 11 also is a bank statement, my lord.
Yes.
That they have received that money.
Correct.
And the check itself at page 12.
Yes. Then,
my lord, then comes a copy of the tax invoice.
what is 13?
These tax invoice I was just submitting a little before, my lord.
What is 13? Annexure O.
13 is a letter. It is issued to the Bardhaman Products by the consignee. No, sorry. We have issued this letter to the consignee.
So it is your letter.
Yes,
2010.
It is my letter because the original is lying with them. So that they will come up with. If I can produce the copy, I can tell them to come up with the original. And there, the next page is of the Road Kings Private Limited, because it is all annexed with that. Road Kings consignment note of the Road Kings. But since the truck went into the gorge, all those papers were inside the truck, and that also went. And therefore, thereafter, it was recovered by the police. And then the documents also seized by the police. So that's why These were not immediately.
So if you are telling that the vehicle was not recovered, how the police has seized?
No, recovered is what? Vehicle cannot be recovered.
Then
suppose
so how
there
the
are
document-
that
the
that would
vehicle-
be in a broken situation. That would be in a broken situation. Caesar made inside the cabin. These documents were there.
Where is the report?
That is there in the JBD because there is a Caesar, there is a chart sheet that we have done. So therefore it is there. What we are now stating that the consignment, how much amount of goods were sent.
This is your document.
Consignee.
This is your document.
This is my document, but the original was sent down to the consignee.
Original is given with the driver.
Yes.
So it can be when it has been delivered, it has to be served to the consignee.
Yes.
So it is your document. So it is your document.
This is my document, but the original was not with us. It was within the.
That's the original. The copy might have been with you. Copy might have been with
you. Copies. That was the office copies, my lord.
Correct. See,
these office copies are there. Office copies
That's
are
why
there.
this of prior to filing of the case.
Yes, my lord.
This office copy, Xerox copy is with you. Correct.
Right.
Yes. Next.
I am not pressing the fifth one because that is an SRCC return that has been given.
Which fifth one?
This
Which number?
This was because all the consignment notes and all. This is 32. Yeah. This is annexure E.
Page 30.
2. Annexure E, my lord. This is an order. This is an order of passed by the Customs Exercise Service Tax Appellate Tribunal. My lord, this is in case of that SRCC returns. That's why we are now doing it. But it was passed on 4th September 2024. Page 34.
Page
34. In the middle, my lord.
For September 24.
Yes.
Yes.
There, my lord, they have held that there was an accident. So, therefore, this amount of SSCC. I am going to the particular. My lord, if your lordships kindly comes to page 38, because I am not troubling other things. As it has been clarified that appellants are required to pay duty on MRP basis, they are entitled to avail abatement while notification date is this. In that circumstances, we hold that the extended period of limitation is not invocable as that date and the method of payment of duty was not known to the department and the appellants have paid duty as per the clarification given by the department. We also find the periodic audit has been conducted at the premises of appellant number 1. In this behalf, Learned Counsel has invited the attention of the bench to pages this. We find substance in the Learned Counsel's argument. In such scenario, it was not open to the revenue to take recourse to the extended period of limitation. We also find prior to the DGCI's investigation in the month of this, and the anti-evasion unit has also visited the appellant's premises, issued spot summons and seized documents. Specific attention of this bench was also drawn because the amount when sent, these amounts, customs amounts, then they impose a tax always.
One has taken a point in the repetition letter also.
Yes, and a point of and this point has also been taken in the repudiation, my lord. That's why this was, though the appellant has placed their arguments mainly on the ground of limitations, it is pertinent.
तुम तो बोले 12:30 इसने फिर 1 बजे क्यों रखा? हम आपको स्पेशली पूछा 1 बजे को 12:30 तो फिर कंटिन्यू नहीं होगा. आप लोग ठीक से बताते नहीं. Okay, matter is fixed at 12:30.
Yes, my lord, that I know.
Counsel for the defendant, you are for the plaintiff.
Plaintiff, my lord.
Counsel for the plaintiff has handed over. The document shows that in compliance with the order dated 28th of July 2025, the plaintiff has paid the cost of rupees 50,000 to the High Court Legal Service Authority. Let the same be kept with the record. Police counsel for the plaintiff has argued at length in connection with GA Com 7 of 2025, but due to paucity of time, hearing could not be completed. Calling matter is adjourned. Let the matter appear on 11th September.
September.
Yes.
Well, can it be any day other than the 11th September? September is 12th?
12th.
I'm free. 12th?
12th September. Yes, next. Item number?
Lord, can statement of truth be taken on record?
My application for judgment on admission.
Judgment upon admission.
Loan given, admitted, confirmations issued, admitted, checks given, dishonor, admitted, 138 proceedings initiated. In reply, they admit that we will pay you by
138 notice.
2022.
by 2022.
And in reply to that, one notice on the page 57. Page 57.
Which
GA are you moving?
My order 12 rule 6.
Well, there are, in fact, there is a demerit application which should be heard first, I guess.
That is only a way to scuttle.
No,
I'll tell your lordship what is the application about.
That's my application. Let me place my
Yes.
application.
I'll just be very short because this has been going on only to scuttle my application, to move my application and recover my legitimate.
My little friend's client had taken adjournment on last 3 occasions. So I have not delayed it, my lord. May I just indicate my application, my lord? My application is by the director, my lord, the respondent number 2 and 3, my lord. They say they have been made parties to the suit only because they happen to be directors in the company. My lord, if I'll take the plaint on its face value, my lord, if my lord wants to hear my application first.
Only defend number 2 and 3.
2 and 3.
My lord,
What about the defend number 1?
Defend number 1, this application is not for defend number 1, my lord. So if my lord wants to hear.
My lord can delete them. My lord can delete them. My lord can record my consent and delete them. That power, even your lordship under order 1, rule 10, sub rule 2, 202, your lordship can exercise that power. Lordship can pass an order and lordship kindly hears me on my GA2.
So GA5 stands allowed, my lord. Their names are deleted, my lord. Very
now let me move my application.
Yes.
Well, it kindly takes my application. There is no affidavit to this application either.
GA5, GA?
GA2.
GA2. Yes.
Well, in GA2, but there is no defense, my lord. I'll not waste my lord time. Yes, there is no defense. There is taken loan, my lord. My lord will not dwell too much on this. The defender 1 has taken loan. They have admitted in writing that the money has been taken, my lord. This application was only filed because they wanted a decree against everybody, including the directors, my lord. I'll be very candid, my lord. The defender 1, let him not labor too much on that, my lord. It's a case, my lord, where I think the money is more or less admitted, my lord. We'll pass necessary orders on that.
Yes, where is the document? Which document? Yes, Mr. Bhattacharya, which document you are relying upon?
My lord will kindly take page 21 onwards. Page 21. My lord, first is the disbursement, which is at page 20. 20, my lord. This is the account from Karnataka Bank. 5th, my lord, 3rd entry from the bottom. 1 crore 16 lakhs and odd. 1 crore. 1 crore has been disbursed.
Yes.
Debit.
By RTGS.
By RTGS.
By the plaintiff to the defendant.
Plaintiff to the defendant. Now, my lord, there comes confirmations after confirmations. I will not trouble your lordship with all the confirmation.
Page 21.
Page 21. My lord, there are several. Page 22, if your lordship kindly takes. And there used to be security checks given with each and every confirmation. So when
the next security check was given, the earlier one used to be returned. But the entire list has been given 1 to 14 up to 2020.
Yes.
My lord, these are the letters. I will not trouble your lordship with all the letters.
Yes.
Now, my lord, the checks your lordship will find page 39, page 40, page 41, page 42. The checks, the interest amount, for that period.
Yes.
40 is the return memo, because your lordship will find the return memo says funds insufficient. 41 is the check, 42 is the return. These are the checks. Now, my lord, I write to him. All dishonored, page 45, I write to him.
Notice.
138 notice. And page 57 is his reply. Your lordship kindly comes to the last part of page 57. He admits would be refunded only after expiry of 7 years from the date of giving, and therefore the due date would be 4th October. Entirely admitted. My clients were thereafter advised to go to NCLT, page 60. NCLT, my lord, held that it is not maintainable, but gave me the liberty, page 60, liberty to approach appropriate courts, and accordingly I filed this suit.
Yes.
My lord, I am praying for, my lord, my prayer is at page 15.
Decree for 1 crore 52 lakhs.
Yeah. With interest, my lord. And this was the agreement.
17. The principal is 1 crore.
1 crore, my lord.
Interest at the rate of 12% per annum.
Yes. My lord will kindly take page 21, because this is the agreement between the parties.
21.
21.
Yes.
There's several of them. We confirm to the amount of intercorporate deposit of 1 crore received from you for 178 days, along with 12%. My lord, this was the agreed rate. It is the agreed rate. So 12%, my lord, is not an absurd figure, because 12% is the agreed amount. Then, my lord, kindly comes to 23, because it is getting extended.
Then 14.
We confirm to renewal the amount for new 183 days at the rate of 14%.
Yes.
So from 12, it got enhanced to 14%.
So he has not paid the interest also?
No. Part of the interest paid. So, my lord will kindly take paragraph 23. I have given the particulars. Paragraph 23 at page 12, your lordship will find 1 crore. So the initial interest was 12% of 17 lakhs 85,000. Then it got enhanced from 2017 to 14%, less what he has paid, 64 lakhs. It comes to 1 crore 52 lakhs 98.
64 lakhs is the interest paid.
Yes, yes.
Principal was there, and first interest from
first interest at the rate of 12% from
17 lakhs.
Yes, 17 lakh 85,000.
89 lakhs. He has paid only 64 lakhs.
64 lakhs.
So 1 lakh 1 crore
1 crore 52 lakhs.
So that is up to the April 2020.
That is up to the date of filing of the suit.
Now filing of this till the realization.
Now after that, on this amount 1 crore 52, whatever your lordship grants interest. And my lord, this is a commercial suit. This is a commercial suit, my lord. I am entitled to costs.
Yes.
The book is with your lordship, my lord. Your lordship, my lord, if costs are not given, your lordship has to give
Reason.
reasons why it should not be granted, my lord. Your lordship knows that. I need not. And
Yes.
I am entitled to interest because it's a commercial suit.
But there is a provision now. The interest, the cost is to be ascertained by the court if the appearing lawyer has to give this fee details.
Yes, a calculation.
That's what Justice Bhaskar Bhattacharya does in arbitrations. He says you give me the schedule of cost along with corresponding payments.
That's right.
That would adhere to all of our benefit.
So, my lord, so far as first defendant is concerned, my lord, I will be very candid, my lord. There is no real defense, my lord. All that my lord can consider, my lord, while at page 69 is the stand of the defendant number 1, my lord. That this loan was for a particular period. That was the agreement. And before
69.
page 69, my lord.
Depending avail the loan.
So this has been the client's stand, my lord. That I have not used any opposition, my lord. Kindly take this as my stand, my lord, and pass appropriate
Paragraph?
orders with paragraph page 69, second paragraph, my lord.
Page 69 of the application.
Of the application, my lord. GA. Oh, so I'm sorry, my lord.
That is
GA.
a plain.
I'm looking at another GA, my lord.
That's why.
I'm sorry, my lord.
Page 69 is the paragraph 5 of the
Yes,
plain.
yes, my lord. I'm sorry, my lord. I was looking at another application. Yes, page 57, my lord. Page 57.
Yes, would be refunded on
That's the stand, my lord. My lord will record that, my lord, and pass appropriate
7
orders.
years when 7 years completed.
To the 2022.
May 2020.
October 2020.
So, my lord, that has been the stand, my lord. I will not, my lord.
Okay.
And my lord will consider, my lord, because of this fair stand taken by the respondent, my lord, kindly consider the cost aspect. But with regard to defendant number 2 and 3 are concerned, there cannot be any decree. Then my lord has fairly agreed to deletion.
Your application is
GA5.
GA5.
Mr. Bhattacharya has fairly agreed to deletion of their names, my lord. That's my lord. GA5 would be allowed, and
I only wanted to expedite my application so that, but I can show my lord that they also, my lord, will kindly take page 21, one of those letters. I would have opposed his application also. And this is being given by the defendant number 2. My lord will kindly note serial number 6. So they agree to bind themselves personally also.
Where?
My lord, page 21.
But you are admitting what can be.
Because I don't want, because attempts to scuttle my application.
Plaintiff has filed the present application. This application order 12 rules. What application you filed? This application under
which
Rule 6.
Order 12 rule 6. Application. The plaintiff has filed an application under order 12 rule 6 of the Code of Civil Procedure, praying for judgment upon admission, being GA Com 2 of 2025. The defendant number 2 and 3 have filed an application, being GA Com 5 of 2025, praying for deletion of their name from the first title of the suit. Counsel for the plaintiff has not raised any objections for deletion of the name of the defendant number 2 and 3 from the cause title of the suit. Accordingly, name of the defendant number 2 and 3 is deleted from the cause title of the suit. The department is directed to delete the name of the defendant number 2 and 3 from the cause title of the suit within a period of 1 week from date. GA Com 5 2025 is disposed of. No, GA2. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 1,52,98,316 along with interest at the rate of 18% per annum. Per annum. Full stop. The plaintiff is a private limited company carrying on the business of non-banking financial institution duly registered under the relevant provisions of financial institution. Full. The defendant number one is a private limited company existing under the private limited company. Full. In the month of October 2015, the defendant, for the expansion of their business, approached the plaintiff for financial assistance. The defendant also represented the plaintiff that financial assistance full list. On the request of the defendant, the plaintiff had agreed to provide short-term loan as financial accommodation to the tune of rupees 1 crore on the basis of the understanding that the defendant shall pay interest at the rate of 12% per annum. As per the discussion between the parties, the plaintiff has paid an amount of rupees 1 crore, which was duly credited in by way of RTGS on 5th of October 2015. 5th October 2015, which was duly accepted by the defendant. On receipt of the said amount, by an order by a letter dated 5th October 2015, the defendant has confirmed that the defendant has received an amount of 1 crore from the defendant for 178 days at the rate of 12% per annum with effect from 5th October 2015 to 31st of March 2016. The defendant has also issued a check, checks in favor of the plaintiff for repayment of the principal amount of rupees 1 crore and for interest of rupees 552, 5,26, 684. In this said letter, the defendant has undertaken that he has issued the said check for honor of the payment paid by the plaintiff, and the bank will not stop the payment as per the check, and the defendant will not close the bank account without obtaining prior permission in writing from the plaintiff. And the plaintiff is not necessary to give any notice to the defendant for presentation of the said check. The defendant will not change the authorized signatories in the bank and will not accept the resignation of the present directors of the defendant company without prior permission of the plaintiff. By a letter dated 1st October 2020, the defendant has renewed the principal loan amount of rupees 1 crore for a further period of 183 days at the rate of 14% per annum with effect on 1st April 2020 to 30th June 2020. And in place of the earlier checks, the defendant had issued 3 new checks of principal amount of 1 crore and 2 checks for the interest purposes, for the interest amount. Again, on 1st of October 2019, the defendant has renewed the loan amount of rupees 1 crore for a further period of 183 days at the interest rate at the rate of 14% per annum with effect from 1st October 2019 to 30th December 2019 and 1st October 2019 to 31st of December 2019 and 1st January 2020 to 31st of March 2020. Again, the defendant has taken back the old check and issued the 3 new checks for the principal amount as well as the interest amounts. Simultaneously, the time and again, the defendant has renewed the loan amount till 31st of July 2016 and issued the checks from time to time. After the period of the loan was over, the plaintiff has presented the checks in the bank, but the said checks were dishonored with the endorsement funds insufficient. After the return of the check with the plaintiff has issued notice under section 138 of the Negotiable Instrument Act on 12th of November 2020 to the defendant. The same was duly received by the defendant, and on receipt of the checks, the defendant has sent a notice admitted the claim of the plaintiff, but only has taken the stand that the defendant would return the principal amount only after expiry of 7 years from the date of giving such loan. Full stop. As the defendant has not paid the amount in spite of the receipt of the amount, the plaintiff has initiated a proceeding under section 7 of the IBC 2000 IBC before the National Company Law Tribunal, but the same was dismissed by an order dated 4th of March 2020 with the liberty for taking appropriate steps, and after the order passed by the Illinois Tribunal, the plaintiff has filed the present suit. Though the defendant has received the writ of summons but have not appeared before this court and now has not. And you had appeared, Mr. You are appearing in the suit also, na? Has received the summons, received the writ of summons and appeared in the suit but has not filed the written statement. Full stop. Counsel for the plaintiff submitted from the documents. It is categorically established that the plaintiff has paid the principal amount of rupees 1 crore to the defendant initially on 5th of October 2015 at the rate for 183 days at the rate of for interest of 12% per annum, and subsequently the set loan amount, the renewal, subsequently on the request of the defendant, the period of the loan amount was extended from time to time, and the defendant has issued the checks. Initially, the interest was 12%. Subsequently, the interest was increased at the rate of 14%. In the notice, the plaintiff has drawn the attention of this court to the checks issued by the defendant, wherein it reveals that the check issued by the defendant was duly presented by the plaintiff, but the same was dishonored with the reason insufficient fund. The plaintiff has also relied upon the reply to the legal notice sent by the defendant on 28th of November 2020, wherein the defendant has categorically stated that page number 57, the aforesaid loan was given by the current 2022. Counsel for the defendant permitted. The defendant has unequivocally admitted the claim of the plaintiff, and as such, there is no defense of the defendant to proceed the case further against the plaintiff, And as such, this is the fit case wherein the court can pass an order and pass the judgment upon admission. Per contra, an advocate appearing for the defendant submit that in these, if the specific case of the defendant in the reply to the legal notice dated 20, counsel for the defendant submit that though the defendant has categorically admitted that submits that the defendant has admitted the claim in the reply, and as such, no further submission can be made. But he submits that for consideration of the interest as well as the cost while passing the judgment upon access. And the learned counsel for the respective parties about the materials on record. This could find that initially as per the request made by the defendant, the plaintiff has transferred an amount of 1 crore in the account of the defendant, and the defendant has accepted the same by way of a letter dated 5th October 2015, and subsequently the said amount was loan amount was extended from time to time, and the defendant had issued several checks, but finally the checks were dishonored, and when the plaintiff has issued the notice for recovery of the amount, the reply of the said notice, the defendant has admitted the claim of the plaintiff. Considering the above, this court finds that the defendant has unequivocally admitted the claim of the plaintiff, and as such, this is the fit case wherein the judgment upon admission can be passed. In view of the above, this court finds that the defendant is entitled to get a decree upon admission for a sum of 1 crore 52, 98, 316, 316 along with interest at the rate of 14% per annum from 1st of May 2024 till the realization of the total amount. Full stop. As this is the commercial suit, full stop. The plaintiff and this is the commercial suit, full stop. The defendant has admitted the claim of the plaintiff. In spite of admitting the same, the defendant has not paid the amount. Have you initiated the mediation process? In this case, a pre-mediation process was initiated.
Yes.
Admitted the claim of the plaintiff.
Page 62, my lord, it was a non-start.
After the plaintiff has initiated the pre-mediation process, but the defendant has not come forward for settlement of the dispute, and the plaintiff was compelled to
61 of the plain
file the present suit. Thus, considering the above, this court finds that the plaintiff is also entitled to cost at the rate of rupees 75,000.
Only one thing, let them deposit this money. Rahul, let's have paragraph 42.6. My lord, on an oral application, let them deposit the money with the registrar.
Come with the execution.
Decree has been passed.
On an oral application.
You got the decree. So I am coming in the division.
Deeply obliged.
Yes, call the list.
Well, this is the contempt petition. If your lordship recollects, we were sitting with Justice Talukdar, that petrol pump matter, 2 writ petitions were disposed of.
Yes.
And your lordship held that the objections given by the Bharat Petroleum as also the National Highway Authority and the private respondent who had the other writ petitioner regarding the Road Congress guidelines and the fact that it is on a national highway, so it cannot be granted. But these were all turned down. Your lordship held in our favor. They went up in appeal before the Honorable Supreme Court. The Supreme Court, after protracted hearing, was pleased to dismiss the special leave petition. So thereafter, my lord, your lordship order of 2022 remains to be complied. Not complied, contempt. On the last occasion, my lord, on 12th of August 2020.
Somebody has appeared on the last.
Yes, my lord. Yes, Mr. Amit Kumar Nag appeared with Rishita Sarkar and my lord. Then they were directed to file a compliance affidavit.
Yes. Have they
Within the
filed
period
any
of, yes, my lord. So they have served
affidavit
us with the compliance affidavit.
Affidavit है? Affidavit compliance आया? कहाँ है?
My lord, we have been served.
Compliance. नहीं है, नहीं फाइल. Nobody.
So I have, yes, we have a copy.
What is the stand? Say.
But first, my lord, kindly see. My lord, this is so elementary. My lord, kindly, your sahib kita debe.
ले लो वहाँ से ले लो.
My lord, I have 2 copies. It's a coincidence, my lord. Lordship will pardon us if it is marked. It's our copy. Now, my lord, kindly have a look at an affidavit of compliance is being filed before the division bench of the highest court of the state by a person who's not even the contender. Kindly see I, Nishit Kumar. Then kindly see para 1, I am the territory manager.
Yes.
I am the territory manager, such and such, and the authorized signatory of the alleged contempt number 9. So there are 9 contemners, not one contemner thinks it's necessary to file a compliance affidavit. And my lord, what is the compliance affidavit? Now, my lord, this is my first objection. My lord, kindly see. They reiterate what was there before your lordship. 2019 this happened, 20 this happened, 23rd. So there's only one paragraph. My lord, till paragraph 19 is, my lord, what was happened before your lordship delivered the judgment in 2022. Then, my lord, kindly come to para 20. Again, reference to your lordship's order. Utmost respect. Then, my lord, kindly take para 22. No deliberate and willful violation. So where is the compliance?
We cannot take this on record. Yes. Yes. Yes, issue.
And my lord, kindly issue a rule. My lord, this is now, my lord. And my lord, your lordship will be shocked. Your lordship conscience will be shocked. In a contempt proceeding, they have filed an application.
Boss, you know, my
not here.
In contempt and in the execution, you know my.
I have not been able to understand how can the bureaucracy be so lackadaisical. It's a contempt jurisdiction.
By an order dated 12th August 2025, this court directed the alleged contemners to file affidavit of compliance within 2 weeks after serving the copy to the learned advocate for the petitioner of the applicants. Though the original affidavit of compliance is not on record, but the learned counsel for the petitioner/applicant submit that a copy of the affidavit of compliance has been served upon them. The copy which has been served upon the learned advocate appearing for the applicant has been handed over to this court, to us. The learned counsel for the applicant brought to the notice of this court to the affidavit of compliance and submits that the affidavit of compliance has been filed by the alleged contemners in compliance of the order dated 22nd December 2022, passed by this court by one Sri Nishant Kumar, who is alleged to be a territory manager within bracket retail Durgapur of Bharat Petroleum Corporation Limited and authorized signatory of the alleged contempt number 9. He submits that there are altogether 9 contemners, but none of the contemners have choose to file their affidavit of compliance in person. He further submits that this affidavit of compliance is not in compliance of the order passed by this court, as none of the contemners have filed affidavit compliance in terms of the order passed by this court as mentioned above. This court, we have also considered the affidavit, copy of the affidavit of compliance handed over by the learned counsel for the petitioner and found that none of the contemners have filed the affidavit of compliance. Even when the case is called, none have been represented today. Right. And no accommodation is sought for. Considering the above, this court finds that this is a fit case wherein the rule can be issued. Accordingly, rule be issued against all the contemners. Contemners returnable by by 25. 25th September 2025 at 1 p.m. 25th September.
Could it be 24th?
24th. Yes, 24th.
Grateful. Deeply obliged.
I'm coming.
Okay.
To trouble your lordship so many times, Lord.
Yes, call the list.
That's right. Contempt application, item number 1, 2.
I pay for the respondent number 5, my lord.
For the petitioner, my lord, the appeal is still pending.
That matter, my lord, appeal is still pending. Let it appear in, still pending. My lord. May it appear in December this time, my lord.
Yep. Petitioner getting the benefit.
Not all, my lord.
Partially, my lord.
Some. Partially they are getting.
It is submitted by the learned counsel for the parties that the appeal is still pending before the appellate court. In view of the submission made by the parties, let the matter be listed. December 11th.
We remain grateful, my lord.
Grateful.
All.
2 to 6 similar order, right?
पता है on with. Thank you.
If in this matter, your lordship said take this matter for examination of the plaintiff's witness, my lord.
Present.
Yes, my lord. The ex parte suit, my lord.
You speak English? हिंदी. Okay. Repeat after me. मेरे साथ बोलिए. मैं कसम खाता हूँ
मैं कसम खाता हूँ
जो कुछ भी बयान दूंगा
जो कुछ भी बयान दूंगा
वो सच होगा.
सच होगा.
मेरे बयान में कुछ झूठ नहीं होगा.
मेरे बयान में कुछ झूठ नहीं होगा.
ईश्वर मेरे सहायता करेंगे.
ईश्वर मेरी सहायता करे.
आपका नाम?
सतीश कुमार झा. सतीश कुमार
Lordship
झा.
will kindly have the judge's brief affidavit
सतीश
of
कुमार
evidence
झा.
and the 65B
सतीश
affidavit.
कुमार झा. स्पेलिंग बताइए.
SATISH
SATISH
KUMAR
KUMAR
JHA झा.
JHH. हाँ. पिताजी का नाम?
अमरनाथ झा.
अमरनाथ झा.
MAR
AMAR
NATH
NATH
JHA झा.
आपकी उम्र?
मेरा उम्र 42.
42 इयर्स. क्या करते हैं आप?
मैं सेल्स एग्जीक्यूटिव एंड अकाउंटेंट का काम करता हूँ.
सेल्स एग्जीक्यूटिव अकाउंटेंट एट कौन सी कंपनी में?
जुपेक्स वाणिज्य प्राइवेट लिमिटेड.
जुपेक्स वाणिज्य प्राइवेट लिमिटेड. आपका रेसिडेंशियल एड्रेस बताइए.
1715
लिखो.
1715
17/15
कफ्ताडांगा रोड.
काफ्ता डांगा रोड. देखो ना.
कलकत्ता 61.
कलकत्ता 61. यस सर.
Effective ना के evidence. May I, my lord?
Yes.
What is this document?
शोना डॉक्यूमेंट. ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए.
ये एफिडेविट ऑफ एविडेंस है.
दिस इज द एफिडेविट ऑफ एविडेंस एंड एफिडेविट ऑफ एविडेंस.
Whose affidavit of evidence is this?
किसका एफिडेविट ऑफ एविडेंस है ये?
ये सुपर प्लास्ट का है.
दिस इज एन एफिडेविट ऑफ एविडेंस
सुपर प्लास्ट
सुपर प्लस इंडस्ट्रीज.
I repeat the question. Whose affidavit of evidence is this?
किसका एफिडेविट ऑफ एविडेंस है ये?
जुपेक्स वाणिज्य प्राइवेट लिमिटेड का.
दिस इज एन एफिडेविट ऑफ एविडेंस ऑफ जुपेक्स वाणिज्य प्राइवेट लिमिटेड.
Who has prepared this affidavit of evidence?
ये मेरे वकील ने बनाया.
This affidavit of evidence has been prepared by my advocate. Been prepared by my advocate.
Are the contents of this affidavit of evidence true and correct?
Yes.
Affidavit में जो बयान लिखा है वो सच और सही है.
Yes, correct.
True and correct.
Who has signed this affidavit of evidence?
किसने साइन किया है ये इस एफिडेविट ऑफ एविडेंस को?
मैंने क्या सतीश कुमार झा.
I have signed on this affidavit of evidence.
Can you
myself, namely Satish Kumar Jha.
Can you identify the signature appearing on the said affidavit of evidence?
इस एफिडेविट ऑफ एविडेंस में जो सिग्नेचर आप देख पा रहे हैं क्या उस सिग्नेचर को आप शनाख्त कर सकते हैं?
Yes.
Yes.
Please identify the signature appearing at the affidavit of evidence.
By marking it with blue pencil.
By marking it.
ब्लू पेंसिल दिए गोल करूँ आपका सिग्नेचर को.
ब्लू पेंसिल.
The witness encircled his signature appearing at the affidavit of evidence.
Yes.
Where have you signed this document?
इस डॉक्यूमेंट को आपने कहाँ पर साइन किया था?
हाई कोर्ट ओरिजिनल साइड.
Not necessary. Yes. You leave it. Next.
What is your position in the plaintiff company?
प्लेंटिव कंपनी में आपका दर्जा क्या है? क्या कर?
मैं सेल्स एग्जीक्यूटिव एंड अकाउंटेंट के पोस्ट पर हूँ.
I am the sales executive and accountant in the plaintiff company.
Since when have you been under the employment of the plaintiff company?
प्लेंटिव कंपनी में आप कब से काम कर रहे हैं?
2014 से.
Since 2014 I am employed in the plaintiff company.
Are you authorized to give evidence on behalf of the plaintiff?
क्या प्लेंटिफ के तरफ से आपको यहाँ पर गवाही देने के लिए ऑथराइज किया गया है?
Yes.
Yes.
Shown
Take that affidavit.
pages 1 to 4 of the judge's brief of document.
मोबाइल स्विच ऑफ कीजिए.
যেটা original copy আপনি একসঙ্গে দিয়ে দাও. And I would leave that, let them convenient for them. Shown pages 1 to 4 of the judge's brief of document. What is this document?
ओरिजिनल থেকে দেখাবো?
যা ইচ্ছা, it's the same documents.
No, that is what is that is a Xerox copy.
That's a Xerox copy.
You are having original.
Yes, we have.
So you produce the original by
Very good.
mention
One by one we'll give the original.
the document which are producing. Give the corresponding number so that it will be recorded.
Very good. Very good.
Repeat the question.
Shown pages 1 to 4 of the judge's brief of document.
Shown the document.
I'll tell you lordship, then it becomes comfortable for your lordship to refer it whenever your lordship is going through in the hearing stage. That's why I was giving the parallel judge's brief of document numbers.
That's why shown the document appearing in page number 1 to 4 of the judge's brief of document.
About shown the document appearing at pages 1 to 4 of judge's brief of document. What is this document?
ये डॉक्यूमेंट क्या है? माय लॉर्ड को बोलिए.
ये डिफेंडेंट का जीएसटी का रिकॉर्ड है.
This is the record of the GST of the defendant company.
How have you obtained a copy of this document?
इस डॉक्यूमेंट का कॉपी आपको कहाँ से मिला? तो कैसे मिला?
हाँ, इसको मैंने जीएसटी का पोर्टल पर जाके डाउनलोड किया, लॉगिन करके डाउनलोड किया. फिर
I got this document after going to the GST portal and after logging in the website portal, I downloaded this document. और कुछ?
मैं डाउनलोड किया.
Yes.
Where have you downloaded the said document from?
कहाँ से डाउनलोड किया?
इसको मेरे ऑफिस में जो कंप्यूटर है उसमें जो प्रिंटर जो कनेक्ट है वहां से मैंने इसको डाउनलोड किया.
I have downloaded this document by my computer which is at my office, and I took a printout of this document from my official printout. I took a printout of the said document from my official printer.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट का जो भी बयान है वो सच और सही है?
यस, सही है.
Yes, true and correct.
Shown document appearing at page 5 of the judge's brief of document.
This is over.
I'm sorry. This document is tendered and marked as exhibit.
Exhibit A.
Yes, sir.
Yes. Shown a document appearing at page 5 of the my lord, may I just, there are altogether 94 invoices. So can I collect, there are altogether 94 invoices. Can I collectively just ask one question for that so that it saves time?
Show all the documents.
Yes, I'll
put
do that.
one question.
Shown documents appearing at pages 5 to 98 of the judge's brief of documents.
Question. What is this document?
Yes. What are these documents?
ये डॉक्यूमेंट क्या है? माय लॉर्ड को बोलिए.
ये हमारे कंपनी ने डिफेंडेंट के कंपनी को जो माल दिया था उसमें जो ये उसका ये इनवॉइसेस है.
These are the invoices of the goods that has been delivered by our company to the company of the defendant.
What were the terms on which such goods were delivered by the plaintiff company upon the defendant?
किस शर्त के बिना पर आप प्लेंटिफ कंपनी ने डिफेंडेंट कंपनी को ये माल भेजा था?
वो मेरे ऑफिस में आए थे, बात किए थे.
The defendant company came to our office. The representative of the defendant company came to our office and we had a talk.
What were the terms that were crystallized during such meeting?
What were the
terms crystallized during the negotiation?
ये जो आपने बोला ना जी ये लोग आए थे आपके ऑफिस में क्या टर्म सेटल हुआ था आप लोगों के बीच
टर्म्स ये सेटल हुआ था कि माल जाएगा उसका 7 डेज के बाद वो पेमेंट करेंगे.
The term was after 7 days of sending the goods, the
Receipt
payment
of the news.
after receipt of the goods, 7 days after receipt of the after receiving the goods, within 7 days after receiving the goods, they will send the full payment.
How have you obtained copies of these documents?
ये सब डॉक्यूमेंट्स का कॉपी आपको कहाँ से मिला?
ये डॉक्यूमेंट्स का कॉपी मेरे ऑफिस में जो आपका टैली प्राइम सॉफ्टवेयर है वहां से मिला है.
I got hold of these documents from the Tally Prime software that is installed in our office computer.
Who has prepared these documents?
ये डॉक्यूमेंट किसने प्रस्तुत किया है?
Prepared.
किसने बनाया?
बनाया.
किसने प्रिपेयर किया है?
ये मेरे ऑफिस में मिस्टर नासरुद्दीन बोल के एक स्टाफ है जिसका यही काम है और मेरे कहने पर जब माल गया था मेरे कहने पर ये बिल उसने बनाया था.
These bills were made by someone, namely Mr. Nasiruddin, who works at our office. He prepared these bills
On
at
my
instruction or on my instruction.
Are the contents of these documents true and correct?
क्या इस डॉक्यूमेंट का जो भी बयान है वो सच और सही है?
एकदम सच और सही है. करेक्ट.
Yes, true and correct.
These documents may be tendered and marked as
Exhibit B collectively.
My lord.
Page 5 to 98, na?
Pages 5 to 98, my lord.
B collectively. Next.
Shown a document appearing at pages 99 to 112 of the judge's brief of document.
What are these documents? Sir,
Yes,
question?
what are these documents?
What are these documents?
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए.
ये लेजर है स्पेस इंटरप्राइज एंड सुपर प्लास्ट का. हम लोगों ने जो उन्हें
These are the ledgers of Space Enterprise and Super Plus
सुपर
Industry.
प्लास्ट इंडस्ट्री
बोलिए और कुछ.
हम लोगों ने जो इन्हें माल दिया था जैसे जैसे माल गया बिल जनरेट हुआ जैसे जैसे पेमेंट आया वैसे वैसे पेमेंट जमा हुआ.
These goods, these ledgers are the records as we send them the goods.
No, this document shows with regard to the materials supplied by us to the defendant and the amount received from the defendant by the plaintiff
And the amount received from the
from time to time.
Great.
my lord.
Who has prepared this document?
ये डॉक्यूमेंट किसने प्रिपेयर किया है?
मैंने किया है.
This is prepared by me. These documents have been prepared by me.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट में जो भी बयान है वो सच और सही है?
यस करेक्ट.
These documents be tendered as
collectively.
evidence.
Single document or
It's only one ledger containing of
continuation?
multiple
It is a one
time-
continuation or separate?
No.
Separate.
Separate.
Collectively.
Collectively.
See collectively.
My lord.
Then shown documents appearing at pages 113 to 120 of the judge's brief of document.
एक बार नंबरটা বলতে বলুন. Yes sir. क्या डॉक्यूमेंट है?
What are these documents?
ये बैंक स्टेटमेंट है.
These are the bank statements.
जुपेक्स वाणिज्य प्राइवेट लिमिटेड का 1/4.
These are the bank statements of Jupex Vanijya
Private
Private
Limited.
Limited from
1/4/2023 से
from 1st April 2023 to
1st December 2023.
1st December 2023.
Who has issued the said document?
इस डॉक्यूमेंट को किसने इशू किया?
बैंक ने इशू किया.
कौन से बैंक बोलिए?
ICICI बैंक.
Document was issued by ICICI Bank.
बैंक.
ब्रांच बोलिए।
ICICI बैंक, जिसको मैंने पोर्टल पर जाके जुपेक्स वाणिज्यों का,
ब्रांच कौन से ब्रांच कहाँ का आईसीआईसीआई
ये
बैंक?
RN मुखर्जी रोड,
आईसीआईसीआई बैंक
RN मुखर्जी रोड।
ब्रांच।
How have you obtained a copy of this document?
आपको इस डॉक्यूमेंट का कॉपी कहाँ से मिला?
ये ICICI बैंक का पोर्टल पर जाके अपना बैंक कंपनी का अकाउंट नंबर डाल के वहाँ से मैंने ऑफिस के कंप्यूटर में जो प्रिंटर कनेक्ट है वहाँ से मैंने डाउनलोड किया।
After going to the official website of our ICICI Bank and logging in there with the name and number of the company, I downloaded this document and took a printout from my official printer.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट में जो कुछ भी बयान है वो सच और सही है?
Yes, correct.
True and correct.
The same may be marked as Exhibit D.
Exhibit D.
My lord.
Shown a document appearing at page 121 of the judge's brief of document.
121 to
Just 121.
only one.
What is this document?
ये डॉक्यूमेंट क्या है? माय लॉर्ड को बोलिए।
ये स्पेस इंटरप्राइज का नाम चेंज हो गया था, मर्ज हो गया, वो सुपर प्लास्ट हो गया, उसी के लिए स्पेस इंटरप्राइज ने मेरे कंपनी को ये लेटर इशू किया था।
This is a letter sent by Space Enterprises. The content of this letter is after merging.
Informing that
After
the name of
the company became Super Plus Industries after merging.
The name of the company or proprietorship.
ये যেটা
আচ্ছা
বলছেন
ঠিক
স্যার
আছে,
আমি
I'm sorry. I'm sorry.
Space Enterprises informing that the name of the company became
has become
ঠিক
Super
আছে।
Plus Industries after the merging.
What is the date of this document?
तारीख क्या है इस डॉक्यूमेंट का?
27/7/2023।
It is dated 27th July 2023.
Can you identify the signatures appearing on the said document?
इस डॉक्यूमेंट में जो सिग्नेचर आप देख पा रहे हैं, क्या उन सिग्नेचर्स को आप शनाख्त कर सकते हैं? आप पहचानते हैं?
हाँ, पहचानता हूँ।
किसका सिग्नेचर है बताइए?
ये सुपर प्लास्ट का जो मालिक है उसका
कौन सा सिग्नेचर किसका है बोलिए? ये सिग्नेचर किसका है?
ये
किसका सिग्नेचर है? ये किसका सिग्नेचर है?
आप सिग्नेचर पहचान सकते हैं या नहीं
आप पहचान सकते हैं।
किसका हो?
ये इस कंपनी का मालिक का सिग्नेचर है।
The signature appearing on the left hand portion of the document is the signature of the owner of the defendant company.
हाँ।
Defendant company. My lord, there is another signature.
और कोई सिग्नेचर है उस पे? वो लेटर में और कोई सिग्नेचर है?
दो सिग्नेचर है।
ये किसका सिग्नेचर है बोलिए?
ये तो सुपर प्लास्ट का ही है।
सुपर प्लस का किसका है?
सुपर प्लास्ट का मालिक का है।
On the right hand side of the document, the signature which appears is also the signature of the owner of the Super Plus Industries. Right?
Why have you not furnished an original copy of the said document before this honorable court?
आपने कोर्ट के सामने इस डॉक्यूमेंट का ओरिजिनल क्यों नहीं जमा किया है?
ये कॉपी मेरे ऑफिस में आया था, मेरे जो, लेकिन उसका ओरिजिनल कॉपी मिसप्लेस हो गया, तो ये जेरॉक्स कॉपी मेरे पास है।
Letter was sent to our office as the original of this document has been misplaced. We have submitted the photocopy of this document.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट का जो भी बयान है वो सच और सही है?
यस, करेक्ट, सच और सही है।
Yes, true and
The
correct.
same may be marked as Exhibit D. Exhibit E.
My lord.
Yes.
Shown a document appearing at pages 122 to 125 of the judge's brief of document.
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए।
What is this document?
डिपेंडेंट मेरे कहने पर मेरे वकील ने डिपेंडेंट के कंपनी को नोटिस इशू किया। मेरा पैसा बाकी था, उसी के लिए मेरे वकील ने उनको
by my advocate
दिस इज अ नोटिस सेंड बाय
to the defendant, calling upon the defendant for making the payment dues against the plaintiff company. Yes, next.
How have you obtained a copy of this document?
इस डॉक्यूमेंट का कॉपी आपको कहाँ से मिला, कैसे मिला?
ये कॉपी मेरे वकील के ऑफिस से मिला।
I got hold of this copy of this document from the office of my advocate.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट में जो कुछ भी बयान है वो सच और सही है?
Yes, correct.
Yes, true and correct.
Yes. Leave be granted to mark the same as Exhibit F.
How you sent?
I'm sorry.
How you have sent?
Okay. How have you sent this document? How has your advocate sent this document?
आपके एडवोकेट ने ये डॉक्यूमेंट को कैसे सेंड किया था, भेजा था?
ये बाय पोस्ट किया था, उसका यहाँ पर
डॉक्यूमेंट वाज सेंट बाय पोस्ट, बोलिए।
बाय पोस्ट किया था, उसका यहाँ पर रिसीविंग है।
The postal receipt of the document is attached here. Is attached along with the document. The postal receipt is there.
Yes. Next.
Now the same be marked as
Received.
Exhibit F.
Track report.
Track report along with the track.
Acknowledgement.
There's no acknowledgement report, only the track
report is not there.
The track.
Not there.
Only postal receipts are there. Track report is not there.
Track report is there.
No, my
No,
lord,
no,
only postal
it's not
receipts. Exhibit F collective.
Collective.
এটাই তোমার এটার সাথে বলে collectively.
Shown pages one.
Yes.
Shown pages 120. Shown a document appearing at pages 126 to 128 of the judge's brief of document. What is this document?
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए।
ये मेरे कहने पर मेरे वकील ने जो नोटिस इशू किया था उसका ये जवाब है।
This is the reply of the notice which was this is a reply of the notice which was sent by me, my advocate, on my instruction.
What is the date of this document and when have you received this document?
डॉक्यूमेंट का तारीख क्या है और आपने कब इस डॉक्यूमेंट को रिसीव किया है, बोलिए।
मैंने इसको 10
पहले बोलिए इस डॉक्यूमेंट का तारीख क्या है।
तारीख है आपका 16 फरवरी 2024।
डॉक्यूमेंट इज डेटेड 16 फरवरी 2024। आपने कब रिसीव किया?
19 फरवरी 2024।
रिसीव दिस डॉक्यूमेंट ऑन 19 फरवरी 2024।
How have you obtained a copy of this document?
इस डॉक्यूमेंट का कॉपी आपको कहाँ से मिला, कैसे मिला?
ये डॉक्यूमेंट्स का कॉपी मेरे वकील के ऑफिस से मिला।
I got hold a copy of this document from the office of my advocate.
I'll not ask true and correct because the veracity of the same is something under.
Where is the original?
Original.
We've handed over the original.
Why you are putting the copy?
I'm sorry,
Why you are putting the question of copy?
Original করে দিন ওটা copy কেটে কেন, because I am referring to the judge's brief, no, shown pages such and such a copy of the, that's why.
ये जो डॉक्यूमेंट आपने पढ़ा है ओरिजिनल है कि जेरॉक्स है?
ये ओरिजिनल है या फोटोकॉपी है, बोलिए।
ये ओरिजिनल है।
This is an original document.
Exhibit F.
Grateful. G. Shown a document appearing at page 129 of the judge's brief of document.
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए। What is this document?
डिटेल कंप्यूटेशन है। मैंने जैसे जैसे पार्टी को माल दिया, वेंडर को माल दिया, वैसे वैसे बिल जनरेट हुआ।
This is the detailed computation of the accounts as and when I supplied the goods to the parties and I received the payments.
और फिर उन्होंने जैसे जैसे पेमेंट दिया।
This is the details of the materials supplied by the plaintiff company and the amount received against these supplied materials.
Who has prepared this document?
ये डॉक्यूमेंट किसने प्रस्तुत किया है?
मैंने बनाया हूँ।
I have prepared this document.
Are the contents of this document true and correct?
क्या ये डॉक्यूमेंट का जो कुछ भी बयान है वो सच और सही है?
एकदम सच और सही है।
Before that, how you obtained this document?
आपको ये डॉक्यूमेंट कैसे मिला?
इसको मैंने कंप्यूटर पे बनाया, फिर मेरे ऑफिस में जो प्रिंटर है कंप्यूटर से लगा हुआ,
In my
Prepared
office.
by me in my office computer and I took a printout.
Are the contents of this document true and correct?
क्या होएगा तो?
The same be marked as Exhibit H, madam.
Yes, next.
Each.
Shown page 130. 3 more documents. Shown a document appearing at page 130 of the judge's brief of document.
ये डॉक्यूमेंट क्या है, माय लॉर्ड को बोलिए?
What is this document?
ये नॉन स्टार्टर रिपोर्ट है।
क्या रिपोर्ट?
नॉन स्टार्टर रिपोर्ट।
नॉन स्टार्टर रिपोर्ट।
Who has issued this document?
किसने इशू किया है ये डॉक्यूमेंट?
मेडिएशन सेंटर से।
The document was issued by the mediation center.
Are the contents of this document true and correct?
क्या इस
How
document
you can see.
Very good. The same be marked as Exhibit I.
Yes.
Exhibit I.
Shown a document appearing at page 131 of the judge's brief of document. What is the document?
ये डॉक्यूमेंट क्या है, माय लॉर्ड को बोलिए?
ये बोर्ड ऑफ रेगुलेशन है जो मेरे कंपनी ने मेरे को ऑथराइज किया है यहाँ पर बोलने के लिए।
This is a board of resolution by which I have been authorized to depose before this honorable court.
What is the date of this document?
What is the
Date of this document?
इस डॉक्यूमेंट का तारीख क्या है बोलिए?
Second April 2025.
April 2025.
Can you identify the signature appearing at the said document, on the said document?
इस डॉक्यूमेंट में जो सिग्नेचर है क्या आप उसको पहचानते हैं?
यस, ये सिग्नेचर मेरे सामने हुआ है। मेरे
सिग्नेचर है, पहले बोलिए।
मेरे कंपनी के डायरेक्टर का।
Yes, I can identify the signature. This is the signature of one of the directors of my company, namely
रजत रतेरिया।
Rajat
रतेरिया।
Rataria.
Well, the same be marked as exhibit. This will be exhibit J.
Exhibit J.
Yes. And shown document appearing at pages 132 to 133 of the judge's brief of document.
What does it?
This is the non-appearance ex parte that has been issued, not required. I'll just exhibit that as K then. In that. May I have your lordship's leave to mark that as exhibit K? It's been issued by the deputy registrar of the.
That is the official document.
Not required. Very well. I bowed. That's all.
Madam.
When the other party will come for setting aside, then you use that document.
Very much. Very.
That's all.
Yes, that's all.
Please step down and stay here.
Any witness further?
No, that's all.
20 witnesses present. During the examination, the plaintiff witness documents were marked as exhibit A to
A to J.
To J. Full stop. Evidence is examination chief of the plaintiff witness concluded. Full stop. Counsel for the plaintiff submit that concluded and witness is discharged. Counsel for the plaintiff submitted. The plaintiff will not adduce any further evidence. Accordingly, the evidence of the plaintiff is closed. Let the matter appear on 16th September for argument.
I'm grateful, man. Is it your lordship's pleasure to give me a slot? I'll take 10 minutes, 15 minutes. No.
10 November.
Very good. I'm grateful.
You try your luck.
Grateful.
For the petition.
Besides.
Yes.
May it please the lordship. For the petitioner, my lord, substitution. My learned friends have made their submissions.
I'll basically, my lord, recapitulate in 5 minutes and I'll conclude my submissions. Dispute between the parties with regard to, my lord, a partnership firm. That's the suit. My lord, when the disputes arose, parties approached the Honorable Court for appointment of an arbitrator. Arbitrator was appointed. Proceeding was going on before the arbitrator. The issue was whether it's a partnership at will. Those 5 basic questions, my lord, to be asked, whether it's satisfied, it's a partnership at will, doesn't satisfy, it's not a partnership at will. The arbitrator, while he was, my lord, deciding the matter, there's a clause, the arbitration clause in the partnership deed says that all the issues may be decided, but the dispute, if there's a step after dissolution, it cannot be decided in an arbitration proceeding. That's there in the clause. In the meantime, my lord, while it was proceeding, we invoked a notice. We issued a notice under section 43 of the, my lord, Partnership Act. And we, my lord, it was a partnership at will according to us. We dissolved the partnership firm. That's very important, my lord. The moment we did that, I mean reply. I'll not take more than 5 minutes and 2 minutes.
Not
That's
required.
what. Very, very briefly, my lord.
You give the reply. Otherwise,
And only this
there
much.
is
Only,
no
only
time.
5 minutes, my lord. I'll not take more than that. My lord, with this, my lord, we terminate, my lord, we dissolve the partnership firm. This is important, my lord, because the entire submission is on the point that you cannot force someone to become a member of the partnership firm. That's why I'm making this submission, because our contention is also the same. There is no partnership firm according to us. The moment this happens, my lord, we terminate, my lord, we dissolve the partnership firm. The learned arbitrator renders a, my lord, finding and then terminates the proceeding. The finding is, it's a 142 or 147 page, my lord, termination order under section 32 of the Arbitration Act, saying that I can't proceed any further. Upon rendering a finding that this is a partnership at will. But since the clause says that I can't proceed any further, I leave it to the party. So, my lord, but the finding is there and then a termination under section 32. They immediately, my lord, the next day, they issue a letter by which, my lord, we had issued a letter for dissolution. Their contention is first removal, expulsion of, my lord, us from the partnership firm, and next the reconstitution of the partnership firm. Now the suit filed by them prays essentially that this letter by which we dissolve the partnership firm be declared as null and void and the consequential reliefs. We file a counter claim, my lord. Our counter claim is that there's a declaration that this letter is correct. Number 2, in the alternative, dissolution by court and the subsequential, my lord. In the meantime, the other proceedings, there are several GAs which are filed. This, my lord, GA 8 is for substitution. Plaintiff, my lord, one of the plaintiffs has passed away. Substitution because the right to sue subsists. That's not denied by them. Our only contention is this: right to sue subsists. No submission with regard to right to sue. All that has been submitted today is that in the meantime, you cannot force anyone to become a member of the partnership firm. I am not forcing anyone to become a member of the partnership firm. All that the petition is for is for them, the legal heirs, to be added as a party to the proceeding, nothing else.
Why?
Because, my lord, we have a counter claim, my lord. Our counter claim touches upon, my lord, rights which have to be answered by the representatives of the legal heirs of, my lord, the deceased partner.
If they are not connected with the partnership, and
even then, my lord, I had shown, my lord, from the Partnership Act, those provisions which say the representatives are also responsible. So, my lord, my right to sue then subsists against them. The main plaintiff, my lord, the right to sue has subsisted against the main plaintiff, and that's, my lord, a case we have made out. So today my counter claim, and I've shown, my lord, the prayers in the counter claim. So today, my lord, all that is required is for them to be added as a party, my lord, substituted in place and stead of the, my lord, plaintiff who's passed away. That's my limited case. 3 judgments which my learned senior friends have shown on the premise, my lord, that a party cannot be compelled to become a member of a partnership firm. I concede. That's not my case. I'm ad idem with the submission apropos that particular, my lord, the ratio, because I do not, my lord, for once it is not submitted that they be made a partner of the partnership firm, because my case is that there is no partnership firm. The only judgment, my lord, which I am required really to, my lord, distinguish is Thakurani.
I'll quickly do that and I'll rest my case. Your Lordship will kindly see, because that's the first challenge which was, my Lord, passed by your Lordship in a decision where the prayer was Order 6, Rule 17. Your Lordship will kindly see paragraph 14 of Thakurani.
Yes.
Paragraph 14, as regards deletion of name of plaintiff 4 on account of death. This is internal page 5.
Yes, yes.
Legal error of the plaintiff number 4 and addition of name of plaintiffs 8 and 9 are not permissible within the purview of provisions of Order 6, Rule 17 of the CPC. In the code, specific provisions have been provided for substitution of the legal heir of the plaintiff on the death of the plaintiff. In the said code, there is also a specific provision which has been provided for addition of parties. So, my lord, I am in agreement exactly what has fallen from your lordship. Order 6, Rule 17. Because there, my lord, there was no separate prayer. It was for amendment of the plaint. You kindly take the prayers in the petition, and that's very different. Page 11. Give me a place where it's taken out. So the first, kindly we'll kindly take up prayer C. Death be recorded, prayer B. Prayer C is, my lord, persons mentioned in paragraph 8 hereof be substituted. So that's a specific prayer. That's my case, my lord. That's where, my lord, I come out of the ratio, because this is not an Order 6, Rule 17 petition per se. It's Order 22, Rule 3, my lord. Now kindly see, my lord, leave be given to carry out. So my B and C is, my lord, my distinction from Thakurani. That's where I may not come out from Thakurani, because in Thakurani those prayers were not there. It was only for Order 6, Rule 17, nothing else. And this is my limited prayer, my lord. The counter claim your lordship will find. May I quickly read out the counter claim? The prayers which we have, I will not read out. Is page 66 of the application, my lord. Page 66. I am not reading it out. This is the reason, my lord, the right to sue subsists. And kindly note, my lord, there was no submission with regard to the right to sue being, my lord, it's still subsisting. That's our contention. It was not, my lord, negated by any submission. That's my case, my lord. I rest my submissions, my lord.
Okay.
And we filed our notes, my lord. Very deeply placed.
How many parties are there?
Yes. There are parties. Very short points, my lord.
I do not know about others, but I have to.
Okay, what?
I have for the years, my lord.
Hearing concluded. Parties are directed to file their written notes of argument within 10 days.
7 days. My lord, then we'll again, the only difficulty we are facing is, my lord, without the substitution petition being decided, all the other proceedings we are facing an impediment, my lord. We have filed our notes, my lord. We have filed our notes.
But directed to file the written notes of argument by 17 September. Why, sir? This is the matter on 17 September as to be mentioned only for filing written notes of argument.
I'm very deeply obliged, my lord, very deeply obliged.
I hope my note is clear in this alleged distinction between substitution and amendment. He also has asked for a
Which I'm not pressing. I've also, my lord, made that submission. I'm not pressing at all. I'm not pressing, my lord. I'm asking for a lesser relief.
Mr. Bagh is not pressing.
He may not press, but if the
Asking for a lesser relief, my lord, now.
substituted don't want to be substituted, how can he take them by the collar and bring them into the hearing?
I've made that submission, my lord. I'm very deeply obliged. Very
Okay,
deeply
let me see. Yes, next.
My application, but exactly, my lord, not exactly, my lord. The distinction over here is that, my lord, the plaintiff has, my lord, claimed for, my lord.
I'm intrigued at their submissions.
Of course, my lord, the plaintiff has, my lord, claimed separate reliefs as against, my lord, the defendants are concerned.
which was not there in the previous matter which your lordship just heard. And moreover, there were no prayer for accounts or in the counterclaim that they had made. But over here, specific money claim against the partnership firm who was the defendant number 1, the defendant number 2 and 3 being the partners, specific prayer in the suit that each of the defendants have to pay. Those are really the distinguishing feature. Mr. Ghosh, for the other heir had completed his submissions, I believe. Mr. Bose was supposed to read.
I have completed. Yes, you have completed.
No, Mr. Rupak Ghosh. Two Ghoshes are here. No, this Ghosh has completed.
Rupak Ghosh also
Rupak
completed.
Ghosh had
He'll
also
reply on
completed.
opening submission.
If you're opening, that was your closing submission. I had taken a preliminary point on maintainability,
Then
that the
yes,
application for substitution is not maintainable.
initially Mr. Bose has taken that.
Correct. So
then
initially,
then Mr. Rupak
submitted
Ghosh
two
came
judgments.
back and said that I have to deal with this point. He's shown 5 judgments. Now I have to deal with those. Now Mr. Ghosh has completed. Now, my lord, before I take your lordship to the 4 judgments or the 5 judgments that Mr. Rupak Ghosh had referred to, well, kindly first see how inapposite these judgments are to the facts of this case. So, well, not a Euclid's theorem. All these judgments have to be applied to the facts of each case. What is his case and what does he want? Well, kindly have a look at the plaint, or in fact the application itself, my lord, that will kindly see the post title of the application once.
GS6, no?
Yes, any application, possibly their application is GS6.
Yes.
Well, your lordship will find there's a single plaintiff, which is a company who claims to be a non-banking financial company. Then, my lord, kindly see the first defendant, which is the most relevant party here. It is a partnership firm.
Yes.
And the other 2 were impleaded as partners of the first defendant partnership firm. This is the distinguishing feature. So, and they have impleaded them as partners. Now, their entire cause of action in the plaint is against the firm. They say that the firm has taken a loan, defaulted, because for recovery of the loan is this present proceedings. I'm not here. I had shown your lordship 2 judgments. I'll come to those judgments later. My lord, kindly take the 4 judgments that Mr. Rupak Ghosh had referred to. My lord, first kindly take the Allahabad judgment.
Which Ghosh?
My lord, Rupak Ghosh. Rupak Ghosh. Well, I am dealing with Rupak Ghosh because Devnath Ghosh is the proposed added defendant. He says that he cannot be, or he ought not to be added as a defendant. So I am the defendant in the suit. My lord, I had relied upon, my lord, Order 30, Rule 4.
Yes.
And I had relied upon 2 Supreme Court judgments. My simple submission was, if the action is against the firm and the partners have been impleaded along with the firm, then in the case one partner dies, my lord, Order 30, Rule 4 does not require, or in fact, my lord, creates a prohibition upon the plaintiffs to implead the legal representatives of the deceased partner. My lord, in support of that, I relied upon 2 Supreme Court judgments.
Yes.
Now, my lord, kindly let us see. My lord, they are trying to deal with my Supreme Court judgments with most of the judgments which are single bench judgments of different high courts.
So your is 2019.
I had relied upon, my lord, 2000. Where's my book?
SP Misro.
Yes, my lord. 2019, volume 10, Supreme Court cases.
329.
Yes, my lord. And I had
another-
also relied upon an unreported judgment of the Supreme Court, which is now been reported, which is
Malsi Dappa.
Yes, my lord. Yes.
Malsi Dappa.
Yes. Malsidappa, which is 2024, it has been reported. So both reported two Supreme Court judgments. Now, my lord, before I take your lordship to those, my lord, kindly take the Allahabad High Court judgment relied upon by Mr. Rupak Ghosh, AIR 75, Allahabad 207.
Yes.
First, kindly take the first paragraph of the judgment. This is a defendant's appeal.
Yes.
Arising out of a suit for ejectment from the premises in question and for recovery of areas of rent and mean profits. Now, my lord, kindly take paragraph 3 once. My lord, here towards the middle of the paragraph, I'll just trouble your lordship with the relevant portion. My lord, the suit was dismissed. Your lordship will find towards the middle of the paragraph 3. Your lordship will find the suit was dismissed. Aggrieved by the decision of the plaintiff, the plaintiff preferred an appeal.
Yes.
Then the appellate court below affirmed the finding of the trial court to the extent that the rate of rent was such and such, contested such and such. Then the plaintiff sued such and such for rent or 1st January and mean profit. Then, my lord, kindly tell why this situation arises and what happened. My lord, para 5, your lordship will find the learned counsel for the respondent at the outset raised a preliminary objection to the maintainability of the appeal. He pointed out that Lala Mohanlal Agarwal, which is the second plaintiff respondent, had died during the pendency of the appeal. And as all his legal heirs were not substituted, the appeal abated as against him. It was urged that the appeal therefore was not properly constituted and could not be proceeded, and it had abated as a whole. Then, my lord, kindly take the next sentence. Counsel for the appellants did not dispute the fact that the plaintiff number 2 had died during the pendency of the appeal and no application for on record of legal error was filed by the limitation. He, however, submitted that as the suit was filed by a partnership firm, Puran Chand and Sons, the plaintiff number in 1, in which the plaintiff number 2 to 6 were partners, it was not necessary to substitute the legal heirs of Mohanlal, deceased in the appeal, in view of the provisions of Order 30, Rule 1. Counsel for the respondents, however, submitted that the suit was not only filed by the firm Puram, but also filed by its partners. Hence, the provisions of Order 30, Rule 4 did not apply. And as the decree passed by the appellate court below was to the benefit of all the plaintiffs, and was therefore a joint decree, the appeal has abated in its entirety. Now, my lord, here your lordship will find at paragraph 7, it deals with these principles of Order 30, Rule 1.
Yes.
Order 30, Rule 1 of the CPC enables any 2 or more persons claiming or being liable as partners and carrying on business in India to sue or be sued in the name of the firm of any of which such persons were partners at the time of accrual of the cause of action. It provides a new and convenient mode of describing a suit, 2 or more persons claiming or being tabled as partners. I think there is a incorrect, but there's a construction of the sentence. There's some inconsistency in the construction of the sentence.
Mode describing a suit to 2 more person claiming a table.
Possibly these are typed copies. Now, my lord, now your lordship will take the next sentence of a firm is compendious collective name for the individual members who constitute the firm. When a suit is instituted by or against a firm, it is in reality a suit by or against all the partners of the firm. The firm name stands for all those persons who were its partners at the time of accrual of the cause of action. In other words, the effect of using the name of the firm is to bring all partners before the court. This enabling provision contained in Rule 1 of Order 30 does not, however, do away with the traditional method of bringing a suit by or against the partners individually. The partners may not choose to file the suit in the name of their firm. They may file the suit in their individual name, either in conjunction with the firm or without the firm as one of the partners. So, my lord, it is, pausing here for a moment, it's a choice. You have filed the suit, my lord. Here it is a reverse situation. You have filed a suit against the firm and its partners. Such a suit would not be a suit under Order 30 Rule 1, inasmuch as under Rule 1, the partners may sue or be sued in the name of their firm. When the partners sue or are sued in their individual names only, and which would be quite legal, the provisions of Rule 1 would not be invoked. My lord, that's why I showed you, Lordship, the cause title. So, Order 30 Rule 1 is applicable in the facts of this case. You have chosen to implead the first defendant as the firm. So the logical legal consequence is that Rule 4 will apply. And my lord, for Rule 4, I have shown your Lordship 2 Supreme Court judgments. Now, my lord, now your Lordship will see what it says. So also would be the case when the partners, the same thing I just repeated. When a suit is filed impeding the firm as well as its partners, the impediment of the firm is unnecessary and the firm as a partner is merely a surplusage, as there is person whom it stands are themselves impeded individual. Such a suit cannot be said to have been filed in accordance with Order 30 Rule 1. To such a suit, the applicability of Order 30 Order 22 is not excluded. Rule 4 of Order 30 applies where two or more persons sue or are sued in the name of the firm under the provisions of Order 30 Rule 1. The moment you implead the firm, so you are suing the firm. Technically, if effectively, my lord, though the single bench has its own view, and though, my lord, it will at best will have a persuasive value on your lordship, Allahabad does not, is not binding on Calcutta High Court, for vice versa, my lord. But your lordship can take judicial notice of that. But, my lord, even the principle which the Allahabad High Court has followed, my lord, squarely applies to the facts of this case. Now, my lord, kindly once take that same paragraphs toward the bottom of that paragraph, where Rule 4 has been, where it starts dealing with Rule 4. About 4 lines from the top.
Which page?
Which page, my lord? On top, your lordship will see 658, continuation of para 7. Para 7, next page, para 7, about 4 lines from the top.
Yes.
In other words, the provisions of Rule 4 would not be attracted if the suit is not filed under Rule 1. Naturally so.
Correct.
Rule 4 dispenses with the requirement of joining. So, my lord, here the Rule 4 principle is reiterated.
Yes.
Rule 4 dispenses with the requirement of joining as a party to the suit the legal representatives of the deceased partner, whether he had died before the institution or during the pendency of the suit, provided that the suit has been filed under Rule 1 Order 30.
Yes.
So this is Allahabad. So, my lord, Allahabad effectively also supports the case that we seek to, my lord, advance before your lordship, which is partnership firm sued along with the partners. So it's a suit within the meaning of Order 30 Rule 1. That's how you have chosen to, my lord, frame your suit. And, my lord, since you're the dominus litis, you have chosen. So Rule 4 apply. Rule 4 says that there is no requirement in law that the legal representative have to be made a party. Your action is against the firm. Now, my lord, your lordship will kindly take the next judgment that they have shown, which is, yes. My lord, kindly take, there's a Calcutta High Court that they have shown, which is AIR 1918 Calcutta 160. It's a very short judgment.
Yes.
My lord, there is a gulf of difference between the principles of Order 30 and section 45 of the Contract Act. Now, this judgment, your lordship will find it refers to section 45 of the Contract Act. Devolution of joint rights.
Correct.
Mane, if you have promised somebody jointly, so that devolution of his right continues to his legal heirs.
Correct.
So the legal heirs can come and say that my father had a right to recover money from you. Since my father has died, by virtue of section 45, I should be impleaded and I will also benefit from the recovery because section 45 principles will apply, which remotely does not apply to the facts of our case. Now, kindly take this judgment once. If your lordship looks at paragraph 1, it will become clear how inapposite this judgment is to the facts of our case. We think that the preliminary objection taken to the hearing of the appeal must prevail. The appeal arises out of a suit to recover money on a such Hatchita executed. Hatchita is, it was in the olden days, if your lordship, handwritten notes, like a promissory note. Yes. So they, in different states, they were called differently. But here it was called, in the Marwadi community is very prevalent. They one scribble and, you can get money, and that is valid. They recognize it. Even legally, it has been recognized that you can maintain a suit for recovery on the basis of that. This is that same kind of a promissory note executed by two persons, namely, kindly make a note of the name Upendra Benad Banerjee and another as managing partners of Calcutta Hoshiari. In favor of Ray Chaudhary and brothers, the suit was instituted, however, by Bindu Bhushan and several other persons as plaintiffs. In the plaint, the description of the plaintiff was the proprietors and maliks of the firm style Ray Chaudhary and brothers. And then the names of the plaintiffs were mentioned. The court below gave a decree to the plaintiffs, and in the decree, the names of Bindu Bhushan and other persons were described as plaintiffs without the addition of the words that they were maliks of the firm of such and such. After the appeal had been filed in this court, one of the plaintiffs, such and such, died and his legal representative were not substituted within that annum. It appears that an application was made out of time and that a rule was issued to show cause why the substitution should not be made though out of time. Rule, however, was discharged, result being that the appeal was dismissed as against one of the plaintiffs, the deceased such and such. Now the decree being in favor of 6 plaintiffs jointly, the appeal cannot proceed in the absence of the legal representative of one of them. The learned pleader of the defendant refers to Order 30 Rule 4, which lays down that notwithstanding anything contained under Section 45 of the Contract Act, where 2 or more persons may sue or be sued in the name of the firm under the foregoing provisions, such and such dies, whether before the institution or during the penalty, it shall not be necessary to join the legal representative of the deceased as a party to the suit. So here the defense of Order 30 Rule 4 was taken. But here the Calcutta High Court held it is contended that the suit was really instituted in the name of the firm Ray Chaudhary brothers. We are unable, however, to take that view. The suit was brought in the name of the particular individuals who are described as plaintiffs and not in the name of the firm. And this is made clear by the decree that was passed in the case. In such and such, in a suit by surviving partners for the recovery of the partnership debt, which became due during the life of the deceased partner, the representative of such deceased partner having regard to Section 45 were held to be necessary parties. So, my lord, had it been instituted, had the firm instituted, or had the situation been reversed, that a plaintiff firm has instituted the suit and during the pendency of the suit, one plaintiff has died. Right. So, my lord, that plaintiff can take, or the plaintiffs yes can take refer to the provisions of Section 45 and say that I have a devolution. I have a right of devolution in terms of Section 45. I should be impleaded because I will get the benefit of what my father was supposed to get from the recovery of the suit. That is the devolution of joint rights. Here, my lord, then your lordship will see the title of the suit was para 4, issued Das and Jagannath, surviving partners of Narsingh Das, deceased who carry on business such and such in the name of such and such. That appears to be a strong case thin the present, order than the present, order 30 rule 4 does not help the appellants as that rule applies only to a case where the suit is brought in the name of the firm. But even if we are, well, again, it supports my case, where a suit is brought in the name of the firm.
Correct.
But even if we were to hold that the appeal can proceed in the absence of the representative of the deceased plaintiff, we do not think that there would be any benefit to the appellants, because the representatives of the deceased plaintiffs can apply for execution of the entire decree against the defendant as a decree. So as it continues. So, well, the principle at best which could apply to the facts of our case is that if a suit is instituted against a firm, would the provisions of order 30 rule 4 apply, yes or no? Then, my lord, here, pausing here for a moment, but I just want to show your lordship one paragraph of the Supreme Court judgment.
How much
that
time will it take?
I will not. I know, my lord, your lordship has a 3 o'clock matter.
And the other, they will get only 15 minutes.
Oh, yeah. Actually, there are 3 more judgments that Mr. Ghosh has
Not
cited.
today, tomorrow?
Very well, very well.
Yeah. Counsel for the defendant number 2 has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear Monday on 8th September.
So Monday it will come at in the usual course.
Or not, you come kar Tuesday kar diye. Monday new
No, Monday, let it be Monday, my lord. Monday. Tuesday is the week.
Yes, next.
Wait.
Right, please, my lord. I appear for the plaintiff in this matter. Your lordship will recall this is the tender matter.
Yes.
That was issued by Bongaon municipality. Your lordships have now heard this extensively. I'd make an endeavor to try and wrap this up today, my lords.
Yes.
Altogether, 5 claims your lordship will recall. First is non-payment of RA bills, delayed payment of RA bills. The second was release of security deposit and earnest money deposit. These are claims A and C that I've already covered before this honorable court. Now, my lords, today I shall place before your lordship claim B. This is on account of, my lords, the extra work or the unbilled work that I have done. So, my lords, altogether 9 RA bills were issued, 8 RA bills were made payment of, 9th RA bill not made payment. I have placed my argument on that count before your lordship. Now, my lords, there are certain works that I have executed but I have not billed. So, on this count, this is my claim 8B, my lords. Your lordship will find at plaint, para 8B at page 25 of my plaint, my lords. Your lordship will?
Yes.
Yes, my lords. So, yes, my lord. I'll directly take your lordship to the convenience volume first and show what the contract states in this regard. So the unbilled work that is there or the additional work that I have done, that also is beyond the scope of the BOQ. So the contract provides for a BOQ which enumerates the quantities and the items that are usually forming a part of the contract, since this is a construction work, my lords.
Yes.
So the unbilled work or the extra work that I have done, for which I have not billed, that is beyond the scope of the contract which I have done at the instance of the defendant. Now, it is my duty, my lords, as an officer of your lordship, to first indicate that there is no written correspondence issued by the defendant in this regard upon the plaintiff to do the work. It's all on the basis of verbal assertions made, and instructions given, my lords. So first, your lordship will kindly have, my lords, Exhibit C. This your lordship will have at page 63 of my convenience volume, my lords. This is the special terms and conditions of the contract that I am placing before your lordship. Page 63, volume 1 of my convenience compilation, my lord.
Yes.
This is where the special terms and conditions begin, my lords. What I really want to place in this is at page 71. This is clause 28, my lords.
Written notes of argument.
Yes, my lord. Those
Volume
contain
one.
three volumes are there. I am
Volume one.
placing volume 1, my lords, for your lordship's kind consideration. Page 63, your lordship will find the special terms and conditions. Start.
Yes.
Page 71, if your lordship will kindly have, my lords. I am placing clause 28 of the special terms and conditions at page 71 of my convenience volume. This forms a part of Exhibit C, my lord.
Yes.
Supplementary items. Any item of work which can legitimately be considered as not stipulated in the schedule of probable items of work but becomes necessary as a reasonable contingent item during actual execution of the work, which have to be done by the contractor when so desired by the engineer in charge.
Which clause you are reading?
Clause 28, my lord.
Any
At the
item?
bottom of
Yes,
page
yes.
71, my lord.
Yes.
Lordship has clause 28. No?
Yes.
Yes. So this clause
Any
is
item of the work can be legitimately be considered as the schedule of
as
probable
not
item.
stipulated in the
The
schedule
work
of
but
probable
becomes
items
necessary
of
as a
work,
reasonable
but
contingent
becomes
item.
necessary as a reasonable contingent item during actual extension of the work will have to be done by the contractor when so desired by the engineer in charge. Now, if
Yes.
you lordship will kindly have the next page.
Hmm.
The rate of a supplementary item shall be derived to the maximum extent possible from the rates of the acceptable items of work appearing in the schedule of probable items. Now, my lords, next para, this is important. To complete the analysis, if necessary, the rates appearing in the PWD schedule as defined in clause 1 of special terms shall be applicable for the portion of remaining work after application of the principles laid down in the preceding paragraph. So, my lords, I today state that I have done additional work of pile cap casting, which was not originally enumerated in the BOQ. And for that, there is measurement sheet. And for that, there is invoices that have been raised, my lords. These form a part of Exhibit O, my lords. I am actually showing these documents from the plaint, my lords, because they do not form a part of my convenience volume. That is why, however, they've been exhibited. So your lordship either has the Exhibit O, from where your lordship will find first the measurements. Give me page 734 of volume 6. 731. These are Exhibit O. It's also there in my plaint at volume 6, my lords, the documents. Page 731 is the measurement sheet.
Yes.
Yes. Your lordship has the abstract of cost, my lord. I don't know in what chronology the Exhibit O is. Your lordship has it? Very well. My lords, date of start is 5th March 2018. Date of measurement is 25th May 2019.
Date of measure 29th May 19.
29th May 19. Correct, my lords. And your lordship will have name of contractor and project on top 2 rows, my lords.
Yes. So this, what is this? This is the abstract of cost.
Abstract of cost, my lord, basis the PWD rate.
How you can?
I'll tell your lordship, my lord. If your lordship will kindly have first the second column that is there of description, my lords. Right adjacent to serial number, there your lordship will find PWD schedule below description. So description of each and every item that is there, my lords. The unit that is
unit, then PWD rate,
then
BOQ rate,
BOQ rate,
then up to
and
date
updated bill.
Okay.
And the rate is 168. That is in terms of PWD rate.
Correct.
And on this count, my lords, I've gone ahead, multiplied it, updated bill amounts. That's how I've calculated it.
So how this amount,
Now, I'll tell you,
so rate
lordship.
you have taken as a 168.
Correct.
So quantity they have taken a 340.
Correct.
Correct. Updated bill is 330.
I'm grateful.
So minus 340 minus 10 is minus. So then 330 into 168.
168 into 330. Correct.
330.
Yes.
So that will come 5 lakh 55,000 55,566.
55,500.
That is 168 into 330.
This should be.
That is correct. I don't think.
Just give me a second. 168 into 330. Yes, my lords, that is more or less correct.
Correct.
55,440 is coming up.
So
to
330 into 160 equal to 55,566.
Grateful, my lord.
So pre-bill, what is the pre-bill?
The
prior bill.
This is the updated bill, my lord.
No, after that 55,566. Thereafter the pre-bill, then rate. What is this?
This is the bill quantity that is there. Same thing, my lords. Your lordship will have identical figures, both updated bill quantity, pre-bill quantity.
Correct.
Same figures, and rate of PWD at 168 is the same, making the pre-bill amount to be 55,566 as indicated in the earlier column.
So why you have given this pre-bill rate, pre-bill amount? This bill, what? Why it is?
I'll tell your lordship, my lords. This is basically to indicate the extra work that has been done, which is beyond the scope of the BOQ, the basis of calculation of the work that is being done.
How you say the extra work?
Extra work because I have not
It's not under the contract.
No, so the scope of work is not under the contract.
Not under the contract.
And I have executed this work but not billed the defendant.
That's it. So first you have to show what is the work in the contract.
Correct.
Correct. And what is the work you have executed.
Correct.
Then the executed work. So how you say this is executed? What is the document with regard to the execution of the work?
I am now taking your lordship.
Because the authorities are not there.
Very
So
well.
if the authority is not there, so there is no MB book. There is no measurement book. So if there is no measurement book, who quantify the work?
My lords, first your lordship will kindly have page 734, the same volume that your lordship. Page 734.
734.
Yes, my lord.
Of volume?
The same volume, my lord. Your lordship was having a look at volume 6, my lord.
Volume 6 is not.
Of the plaint. Same volume.
Seven
734, my lord.
Yes.
Yes, my lord. Your lordship will find this is the measurement sheet.
Correct.
Like your lordship has now put on a very pertinent query as to what is the basis of your calculation there. How have you done the work? What is the proof?
Correct.
So this, my lord, measurement sheet, the first batch of work that is there, which is represented as item number 4. That is the concrete measurement, the concrete work that has been done, which I am informed is beyond the scope. I'll also take you through the BOQ, my lords, but the only difficulty is us being normal, reasonable persons in the BOQ and the work done. These are all engineering terminologies and concepts that have been used. So whatever little I
Very
have been,
simple.
yes,
Nothing now, no terminology.
I whatever little I have been able to ascertain, I'll place before your lordship, and then your lordship will be in a better position to adjudicate. So item number 4 is concrete measurement that is there. This is beyond the scope.
Where where you say?
Batch mixed concrete of
735.
grade.
Correct.
Yes.
735 is with regard to the construction of, that is the name of the work. Agreement sentence. So how you can say?
So your lordship has 734, my lord.
34.
Yes, my lord. That's what I want. I'm sorry, my lord. 734, your lordship will have first the name of the project naturally is there, and date of measurement your lordship will find is 29th May 2019.
Correct.
Item number 4 is what I was placing before your lordship, my lord. This is the concrete measurement that is
item
there.
number 6, 736. Can you see the column? Item number 6.
Item number 4. It's actually digital, but it has same much 734.
You see. No, item number 6. Sir.
My lord, your lordship. This is the one, madam. I'm sorry. This is upside down also actually.
Not up and down. I am giving a suggestion. If you want to make a document 4-5 copies, only one document first to paginate, then you get it Xerox.
That is actually a very smart
Then
thing.
it will be serial.
Correct. It's a
Otherwise,
prudent thing to
if
do.
you go first, you get it Xerox of 4 sets, and you by sitting and putting the number, then
Correct.
all the number will
Above.
be never tally.
Yes.
Yes, is the item number 4.
Item number 4, your lordship
Correct.
will have. Fine. So batch mixed concrete of M25 grade.
Correct.
Not there in the BOQ. This is what additional.
No, see, this measurement book prepared by you.
Yes.
Correct.
Does not contain the signature of the defendant. This is something that
And
I
what
can
is
say.
the law? What is the law? Measurement book, the site engineer will every day or every week or every fortnight, whatever it is, as per the contract, site engineer will prepare the measurement book, countersigned by the contractor, sent to the higher authority.
Correct.
Then if the higher authority want for clarification, then with the consent of the contractor, it can be rectified.
Correct.
Here, that's why earlier when I have fixed for the judgment, then I have gone through, I find this all the document not contains the signature. So how you say this is the measurement?
I'll tell you, lordship, my lords, what you are saying is precisely correct. Now what's happened is that the contract awarded to me in 2018 got over in 2019. However, I've continued to do the work. Finally, in 2021, I give up. I say that I cannot. I am abandoning the project and I'm going. June 21. And July 21, they've taken possession of the site. Now, naturally, my lords, I'll tell your lordship, in such cases, when I have decided to exercise my right to terminate the contract and they have subsequently taken possession thereof, there is no correspondence or no measurement sheet that they will now sign for me or endorse, even if I have done the work. So I have to come before your lordship with the limited scope of documents that I have.
No, that's correct. What you have, but how the court can believe on that document unless it is authenticated?
I bow down before your lordship.
Or if not, then this is to, if it is not signed by the authority, then you have to adduce a corroborative evidence. Yes, this is the work we have executed. There is no.
So for that, I have annexed the photos of the work that I have done. But there is only so much that we can. I bow down to your lordship. It's a very genuine concern, my lord. Just because I'm appearing for a party at the end of the day, I have there to assist your lordship first, my lord. So far as the documents are concerned, this is the measurement sheet on the basis of which I am relying upon, my lords. Good, bad, indifferent. But this is what the plaintiffs are relying upon to today's state, that they have completed the extra work. And on and from 746.
So where is this? Where is the letter? This measurement was submitted to the authority, and authority has received that, and they have not acted upon. Then the court can presume, yes, this is the measurement. Though the authority has not taken the measurement, it has been taken by the contractor, sent to the authority, and authority has not revert back to you. So deemed admission.
Lordship has spent enough time across the bench as well, so these are very pertinent points falling down, but these documents are not there. So there is only so much I have to submit on the basis of the document.
Come on next. Counsel for the petitioner has argued, plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on Tuesday.
Lordship, pleased to have it on
Tuesday.
Tuesday, same time, my lord.
May I have my lord's?
I have not picked the time. Let it be come in the list. We'll see to that.
Mentioning for extension of interim order. The interim order is expiring today, my lord.
It is listed.
It is unlisted matter, my lord. It's a non-commercial matter which
non-commercial. How it is?
If my lord takes up the first paragraph, GA1, that allows the athletic club matter, my lord.
No, it is before this court.
Before this court.
Matter.
Not assigned. My lord has marked it as a part hard. My lord, if my lord takes up the paragraph 1 of my lord's order.
The counsel for the plaintiff.
Plaintiff.
Prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till. It is not in the list.
Not in the list.
The 19th of September 2025. This is the matter on 19th September.
On the interim order till
19th September. Yes, anything?
May I permit to mention my matter?
Yes.
Item today.
Any interim order?